42.
42 for hearing matter.
My lord, item number 59, my lord. Maybe take it up next week. Like, a hearing matter.
That will be in the weekly list.
That
I'll put it in the weekly list. So whoever is asking adjournment, put it in the weekly list. End of the weekly. At that. Yes.
21.
Permitted to withdraw. Item 21.
21, withdraw.
Lordship.
Take the memo, withdraw. Yes.
Lordship, item 40 and 51 on behalf of Mr. B.R. Dalai. Kind paper an adjournment, Lordship.
That will go to the weekly list.
51. Lordship. 40, 40, 51. Again. 45 points.
Yes. Any more mentioning?
Item 1. May I please, Your Lordship?
Yes.
307 along with other offences, my lord. Custody since 26/11/23.
26.
11/23. Charge sheet submitted, my lord. 22/3/24.
Yes.
Injured recovered and he was held under T, my lord. Moving in the village. Allegation is that the petitioner along with others abused in filthy language, also assaulted, and so far as the Niranjan Das and
That is.
Earlier, my lord, so far the item of 2 is concerned, my lord. Your Lordship earlier rejected the prayer for 3 of the petitioners and directed them to move after submission of charge sheet, my lord. In the meantime, charge sheet is submitted, they have application moved there. What happened in this case, my lord? Offense 307 and they sustained injury on their leg and hand and other part of the body, my lord. Lordship last time asked me to take instruction regarding injury, my lord.
Injury.
So
Yes.
far, my lord, the
Because he hurling a bomb.
bomb, my lord.
yes, my lord.
Whether
Yes.
leg and everything is.
No, not amputed. He is moving, my lord. This is the photograph I have obtained.
No, he has to.
Yes, ma'am.
Sunyavas, my lord, the sustained injury, my lord.
How many people have sustained?
2 persons.
2%.
Okay.
Sunyavas, my lord, he has sustained injury. One injury is grievous in nature. And so, according to my lord, another injured, my lord, he also sustained one injury. Rilachal Das, my lord. Also, his injury, one injury is injury number 1 is grievous in nature, my lord.
No, grievous is all right. Whether legs and everything.
No.
Then, there's
He is moving, my lord.
sustained injury, but I had given the photocopy of the injured, my lord.
সেটা ফার্স্ট ର ଏଗୁଡାକ ରିସେଣ୍ଟଲି ଆଜ୍ଞା
Injury. I would do that.
Srinivas Das.
ଆଜ୍ଞା
Antecedents?
Antecedents, my lord. They are not sent.
antecedents so far as the second case is concerned, they have no antecedent. So far as the one is concerned, it is ek number having cases, my lord. ये 506 ये village
They have
dispute.
antecedent.
आगे.
Because the bomb.
A condition, nahi, they have not hodl bomb, my lord. As per your lordship, kindly turn to page Nilach and Niranjan and Ranjan.
Have you filed this?
My lord, I will, your lordship that kept in the record, my lord. I was sent this same, my lord.
But it has to be filed on record.
Correct.
Online, na?
Correct.
You file an affidavit, tell the IO to
Well.
file an affidavit along with this and the antecedents and putting on Tuesday. Mr. Ragada has hands up for the instruction, written instruction given by the SI Kalikot people. However, in the instruction, the antecedent of the questions are not mentioned. Accordingly, the matter is adjourned to Tuesday. Tuesday,
Condition maybe.
Tuesday. Date लिख दो, Tuesday date लिख दो. The SI, the IO is directed to place on record the injury report and the antecedent of the accused persons in both the cases. 1 and 2 दिया कर दिया मंगल पाई करो
If he'll send the antecedent, I will supply the report.
नहीं नहीं आप record धरी पड़े ले I'll agree
ସେଇଟା
I'll
record
record that
ରେ
and
sir,
send to you.
Madam.
Record that and send to you. Otherwise see
हाँ madam.
ଆଜ୍ଞା antecedent ଥିଲେ condition ଆଜ୍ଞା ଦେଇ ଦିଅନ୍ତୁ ଥାନାରେ appear କରିବ।
ଦେଖିବା then you
Charge
say that
sheet
there
ରେ-
is no antecedent.
So far as the second
Accordingly,
case
I'll
is
have to
concerned.
see I'll have to modify the bail conditions. That's the idea.
Aye.
That's the idea.
They have not Hon'Ble bomb. As per rejection order also says Niranjan Das, Ranjan Das threw bombs. And he was hell and heady. I have 5 photographs, my lord. Let them verify, my lord. I have supplied to Mr.
Give.
ଆଜ୍ଞା ସବୁ ଯଦି ଦେଇ ଦଉଛି ସେ ବୁଲୁଛି ଆଜ୍ଞା
Madam, मागे
ବଜାରରେ
station health condition मागे दोची दे देबे.
Health condition.
ଏଠି ବୁଲୁଛି ଆଜ୍ଞା
ना
ବସୁଛି
health condition
ସବୁ
मागे दोची
Health condition. Why do you worry?
मागे दोची.
307 your lordship knows
Bombing actually.
ନାଇଁ ବମ୍ବିଂ ଇଏ
Otherwise-
କରୁନାହାନ୍ତି
Otherwise, you know, 307 I grant.
ଆଜ୍ଞା
that.
granting
Anticipatory
anticipatory bail what happened my lord they have not throwing bomb there is a tussle between them all on a sudden 2% came they have ordered bomb
Which is this place?
a Khalikot ଆଜ୍ଞା
That area I know.
he go
Earlier it used to be very serious. Now in between now some at least peaceful they were maintaining. Now again it is bombing and thing is
no
started.
bombing since long it was
Anyway,
since November my lord
anyway, let
But
me give.
If they
Tuesday.
produce the record, my lord, yes, there is and the antecedent, I will produce on this.
Yes. Then we will modify the bail conditions. Because see, he is in custody from November 2023. Hmm.
7 months
About 10 months. And charge sheet has been filed in March 2024. So only the conditions has to be imposed according to their antecedents.
Urgent.
Tuesday.
25th.
Yes. Yes. 2 भी है ना?
2 भी सही
हाँ, 1 and 2 मंगलवार पे रखो. And 3.
So, but 2 is concerned, you will rejected earlier and direct him. to,
नहीं liberty
move
was
after-
granted
some
move afresh after charge sheet
Charge
filed.
submitted.
Parity.
Ekadhi
Yes. Next.
Item 3.
3. 3. The,
The case there is required in this case, my lord. 302, offense 302.
issue notice, call for the case diary, list, July end of July. Yes. Yes.
Item 4.
My lord, permitted to withdraw, my lord.
Permitted to.
On memo.
Item 5.
Why are you withdrawing? Why the
What happened? This petition, you also granted bail to this petitioner, another counsel appearing in.
Yes, my lord.
Again, they have filed in spite of anticipatory in their favor.
Okay.
Fine.
Item 5.
What is this?
5, my lord. The case of a
Modify the condition.
order dated 16/1/17.
18/9/2013.
Earlier, man, 3 occasions, nobody appeared, man, for that.
Nobody appeared. Proceeding fine. 2017.
Next week. Nice. 23 next week, 23/2017 28/2017 next week, 24/2017 next week, 22/2019 next week.
এটা পাস কरो ডিসমিস করে দাও if nobody comes may not be interested also
Only document with
the condition bail condition modification may not be interested. Yes.
item 6.
Why this CRLMC has come? What is
Modification
this?
of order.
Modification.
Disposal case.
What modification is seeking? What is that modification application? Yeah, this one. Application note. What does you want? Okay. Paragraph 5.
They have not given me copy, my
Direction was issued to learned additional session judge Kamakhya Nagar instead of SDGM Kamakhya Nagar. Wait, SDGM. Pending before the learned additional DC judge Kamakhya Nagar. Inadvertently, direction was issued, para 5 just see.
But they have not
Inadvertently,
given any
direction
copy,
was
my lord.
issued to the learned additional judge Kamakhya Nagar instead of additional SDGM Kamakhya Nagar, not to execute the NBW function. Let him come pass it over. Yes.
7 no instruction, ma'am.
Sir.
Old matter meanwhile, cancellation of bail, I
Learned
think.
counsel for the petitioner submits that there is no inspection he has received from the his client. Accordingly, he doesn't want to express.
My lord, I am appealing for item 6, my lordship.
6.
Yes, my lord.
What do you want?
My lordship, with that opening portion of the judgment, my lordship, instead of STGM Kamakhya Nagar, that is typographically mentioned as
Because in the prayer you have written, in the prayer portion of your petition,
yes,
you have said it is pending before.
that
the court of-
typographical error, my lordship, inadvertently that mentioned is
That's the problem. From prayer it is taken up.
my
That
lord.
one. Instead of additional district and stations as Kamakhya Nagar, SDGM Kamakhya Nagar. In the last paragraph. Last paragraph of order dated 23/5/2024. ठीक है?
I beg pardon, my lordship, if possible, time may be extended someday.
Yes, time was granted to you till
July 15, my lordship.
July 15. It's all right.
My lordship, at least settle up my family, at least 2 months is required, my lordship.
No,
Then,
no, no, no.
my lordship,
No,
I
what
know
2
the
months?
future of this client, my lordship. When I appear before this court, I am definitely going to the custody.
See, the NBW was issued when?
NBW was issued, my lordship, order dated 9/9/2023, my lordship.
So then
Till then, I am absconding, my
you
lordship.
will choose the time.
No, my lordship. I am prayer before, my lordship.
Now
I
you will
pray.
choose the
No.
9/9/2023 NBW is issued. I gave intelligence till 15 July.
My lordship.
And now you will choose
Only
and
only 10 to 15 days, my
I
lordship.
give a direction that the court should come to your house and conduct
No,
it.
my lordship. No.
That's better idea.
No, my lordship. No, my lordship.
What is this? NBW I am cancelling and I have given July
My
and
lordship,
you want 2 months.
my lordship, I know my fate. When I appear before this court, before this law and trial.
What is the offense?
302 and 147, 149. My lordship. This is Danga, my lordship. This is case of Danga. And entire opposition.
Then this is basically an anticipatory bail
But it is a
Till-
Danga,
till-
Danga, my lordship.
for 2 months.
That entire portion of the
Okay,
opposition.
in view of this confusion, the petitioner seeks extension of time to surrender before the court. Accordingly, the time is extended up till 30th of July.
My
Okay.
lordship.
15 days I have.
My lordship.
Okay. But you surrender and
Yes, my lordship. I am ready.
yes.
Item 8.
Yes, sir.
To the opposite parties. I
You
am
are
to the
finished?
opposite parties.
What is this matter?
That is cancellation of bail.
Bail granted when?
Granted in 2016 now. On that case, my trial evidence of the respect of present accused persons have been closed. My lord.
Already evidence is
Evidence closed. Another de novo trial has been ordered because of the 319 petition filed by the against other who have been.
what was the ground of cancellation?
One another case has been
Registered
lost.
again.
That has been acquitted now.
With the council. Counter affidavit? None. Of the cancellation. I just pass over, I'll take this piece. 2016 bail granted. Now the trial is at the fake end.
Yes.
Trial is at fake end. And the ground of cancellation is the accused is involved in some other case.
And that.
And that case also you are acquitted.
Acquitted.
That will have to.
Yes.
This much. We will pass it over. Yes.
Item 9.
9.
In item
Yes, sir.
9 In item 9, I am for OP number 2, my lord. My bail cancellation application has been filed.
What is the ground?
Against my bail, they have filed application.
Why? What ground?
Ground was that after my release from on bail, I threatened them. Subsequently, 3 cases were filed. In one of the cases, I was acquitted. Also, my lord, at that point
3 cases were registered against you.
my lord, after my bail, out of them, in one of the cases, I was acquitted. I don't know the status of other 2 cases. Also, at the time of filing of this CRLM application, out of 17 witnesses, 11 witnesses were already examined.
What is the offense?
302, my lord.
You are granted bail and you are coming out and
I did not, my lord.
involved in 3 cases.
No, I did not, my lord. One of the cases I was acquitted, and other cases there's
So offenses in all these 3 cases.
the 506 that I am threatening them over phone.
Are you have you threatened the witnesses?
No, my lord. They have not even produced the SIM card. Also, in that acquittal order, they have stated that from jail I was threatening.
Yes, Mr. Rahul.
Yes, my lord.
What is the stage of the trial?
Yes, my lord.
11 witnesses were examined at that point of time.
There is no instruction with me, my lord.
17. It is
How many witnesses are there?
17 witnesses.
11 already examined.
No, I have to take instruction, my lord, because there is a
Next week,
counter
when
affidavit
is it?
copy has
When
not
is
been
it?
served to me.
You get the status of the other 2 cases and how many witnesses have already been examined?
My lord, State Council can obtain that instruction because we are not able to contact the.
You'll also try. You also do it. Yes.
Yes.
Wednesday, Thursday. Yes.
Item 10.
What is this matter? Entry motor pass on continue. What does he want? Yes, Mr. Rahul, what is this matter?
For the modification, my lord.
Modification.
Yes, my lord. Item number 10.
Huh.
Modification.
Modification of what?
Modification, my
Hearing
lord.
the application and hearing the parties necessary orders quashing the impugn order dated 26/10/2016, Annexure 3. Annexure 3. What is this order 26?
Total amount, my lord, 1,28,000. Deposit by order ହେଇଥିଲା ସେ order ଟାକୁ challenge କରୁଛନ୍ତି.
26. The advocate has present in the court, he files 2 separate petitions in one of the appellant to pray the court to permit him to deposit 30,000 rupees in another petition. He pays the deposit.
They're praying for 3 equal installment. My lord.
So, the appellant was directed to deposit. Appellant was directed to deposit 1,20,000.
My lord.
1,20,000 nationalized by so and so, advance, petition for 1 month time.
He is prayer for equal installment, 3 installment. 10 को.
And he is jolly well taking stay and
Council is coming.
yes.
Sorry, madam.
Direction was to deposit 1,20,000. And then you moved application that I'll deposit 30,000 and 90,000. Okay, that was turned down. And you came to this court, obtained a stay since last 2016 and it is pending.
The conducting council, Mr. Naik is out of station. Can you take up?
I'll vacate the stay.
Madam, Monday, kindly taken up Monday.
What is this? 1,20,000 rupees you are supposed to deposit as per the bail condition. You asked for installment. That was turned down. You came to this court, obtained a stay and jolly well waiting till 2016.
the conducting council is out of session. For that reason, I pray only one day.
From 2016 is out of session.
No, today.
Okay, Monday. I'll vacate this stage.
No,
After this.
Monday, he will
Monday
have-
on your request.
Fine.
Okay.
Item 11.
On my protest petition, your lordship may kindly turn to page 33.
33.
3.
This is preliminary. 33.
I'm seeking cancellation of bail.
Bail granted when?
My lord, I'm coming. Your lordship may kindly see page 33, order dated 14 to 23.
Yes, I'm there.
This cognizance was taken 417, 420, 506, 409, and 34
In the protest petition.
in the protest petition. Next page, accused persons are absent, issue summons to accused person fixing 8/5/2023 for appearance. Then your lordship may see 8/5/23, they are again absent, that is at page 35. At page 36, on 25/8/2023, bail is granted. So much. That. My lord will kindly see page section 437.
Yes.
409, there is a life imprisonment.
Hmm.
My lord, when bail may be taken in case of non-bailable offense. When any person, I'm sorry, your lordship.
I'm there.
When any person accused of or suspected of, there are commas, the commission of any non-bailable offense is arrested or detained without warrant by an officer in charge of police station or appears. My lord will kindly see or appears. Or is brought before a court other than the High Court or the Court of Session, released on bail, but such persons shall not be released if there appears reasonable grounds for believing that he is guilty of an offense punishable with death or imprisonment of life. Here the magistrate, JMFC, should not have entertained that bail. Bail has to be presented before him. Can he grant bail without any reasons? Because
He might have moved an application.
yes, he has moved an application for bail and bail was granted without any reasons. The Honorable Apex Court in the latest judgment has given this finding that without any reason, and here the embezzlement of
There are the other judgment says that reasoning is not required.
But it is your lordships will decide. But 437 statute is clear that where there is an imprisonment.
Which offense according to you is attracting life?
409? 409, he takes cognizance. Malad, he takes cognizance, directs them to appear, they don't appear, suddenly they appear, and your lordship will see the bail order. No reasons has been provided, no conditions have been fixed.
Then tell me what condition you need.
Malad, he should deposit 50% of the money. It will be deposited in court. I don't say
What
that
is the involvement?
2 crores 35 lakhs. And I have got the documents under Right to Information Act, page 38.
Who is appearing for accused?
My senior, Mr. Bagi.
Yes, sir.
And your lordship will see page 38. This is the bank
The
statement.
biggest problem is if two legendary civil lawyers appearing, reading line by line. then
My lord,
in a criminal matter, there is a problem.
My lord, we are learning from our senior. I am nobody. I'm just.
Two things are involved in this case, my lord. Though the offense is tribal magistrate, my lord, magistrate can't grant bail in so far 409 and 326.
I
They are
understand.
imprisonment, life imprisonment, my lord.
That's the reason I'm
Second
asking.
thing, my lord, if the magistrate granted bail, my lord, they have to file concession before the magistrate answers to 435, my lord.
That also, but I'm
two
trying to sort out
My
this
lord,
thing.
oblige.
Wrong, right, whatever.
My lord.
There is a bail. I was telling yesterday, when the trial court grants bail, the High Court should be loath in interfering because we are discouraging the trial court to grant bail, basically. That should be there. But in the same time, if 2 crores is involved, if the condition is modified to some extent, will be a balancing act.
Yes,
That is why I'm asking the
I will-
learned senior if we can ask.
All your lordship may kindly see 409. My book says it is 10 years, not life. So triable by magistrate. Your lordship may kindly see that.
10 years, okay, maybe. So
And triable by the magistrate. My book says, I do not know whether it is amended or not.
Life is.
100,
409.
409.
Implemented for life. If or implemented for 10 years.
Matlab that's an or, life or
Or.
10 years. Or
Like
with
it.
fine, with both with fine. Your lordship may see this.
Anyway, that is not the matter, my lord. Now your lordship may kindly see. Initially, the FIR was filed. In the FIR, final report was submitted. On the ground that there is a dispute between the management versus teaching and non-teaching staff. The management, the informant who resides in Bhubaneswar, wants to close the institution, and he has misappropriated near about 15 crores. But to run the institution, his aim is to close down the institution, that is engineering institution, my lord. So the teaching and non-teaching staffs, along with other management, they resolve to collect the tuition fees and other charges from the student and to keep in an account for payment of the salaries of the teaching and non-teaching staff. In the ICICI bank, they have kept the amount. Now, my land friend.
Who are you? Who are you?
We are the teaching staff.
No, they are the removed employees of the staff.
I am coming.
They have been dismissed from
Court is
service.
asking a question, I will answer.
1 minute. Yes.
Now, by the process, when we resolve to continue the institution, he removed 21 teaching staffs and some non-teaching staffs arbitrarily, though they have served more than 11 years. Now this institution, they run the institution. Now at this moment, your lordship may kindly see the charge sheet submitted, final report submitted by the court, police.
No, that is why protest petition.
Yes.
No, my lord, I am taking a lordship. Not that the finding recorded by your lordship may kindly turn to.
No, yeah, why should I get into? Because the superior finding of the court and
No, my lord,
protest petition
because-
is there. The police finding is not very important.
That I understand, my lord.
Yes.
But a counter case is also filed, and he is in against him for misappropriation of 15 crores. And they have challenged it. He has challenged it for causing the cognizance.
You just
Now, question is, there is no misappropriation at all.
My lord may see page 38.
Rohantu, let me finish or you
yes,
complete?
let him complete.
Let me finish. Now, your lordship may kindly turn to page 38 according to him.
38. Okay.
Now, the deposit, your lordship may kindly see third column, serial number 1, first column and deposit.
Yes.
These are the deposits and the period is in the first column. And withdrawal is this, the balance is this, and it has been audited. It has been audited.
Who
This-
audited it?
This withdrawn is from where?
Withdrawn from the ICICI bank, my lord.
The
The account-
of the institute.
No, my lord may kindly see above.
I am unable to
One
ask
minute,
my lord,
let
what is
him-
this? He is showing us.
Continue.
Who is showing us?
Because he has got the bail. He is facing the
No,
music.
my lord, facts we should be proper. Your lordship may.
You get the opportunity to clarify.
Yes.
Yes, sir.
So this accused person, along with other teaching and non-teaching staff, on resolution have opened an account in the ICICI bank. The amount collected from the students towards tuition fees and other charges are being deposited in that account. And these are the deposits, my lord.
Who has withdrawn this money?
And two persons from their operating jointly, operating the account jointly.
Which opposite party number?
That,
Who has withdrawn this money?
my lord, I am taking this. Now, Sukanta Kumar Mahanti and Sarat Chandra Sahu,
1 minute.
joint account holder.
1 minute, sir. 1 minute. Sukanta Mahanti. Sukanta Mahanti is opposite party number 2 and Sarat.
He is the principal in charge,
2 and 3 have withdrawn this money.
my lord.
Okay.
And it has been paid as salary and other expenses of teaching and non-teaching staffs.
This 2 crores 75.
Yes. And the
That's-
institution is continuing. Now, your lordship may kindly see. Your lordship may kindly see for a moment. On the affair of the teaching staffs, a case has been registered against this petitioner. And cognizance has been taken. And the allegation is there is 15 crores.
Banshidhar Pradhan.
Yes, here is petitioner.
Petitioner is, I think, the institution. Petitioner is calling an institution.
No, my lord, Bangshidhar Pradhan, he is the, I'm taking a lordship to all the material facts.
By its founder trustee come.
Yes.
Bangshidhar.
Now, fact remains, my lord, it is a registered trust. The institution by a registered trust. There became dispute between the trustees. Most of the trustees resigned. Now the institution, the trust is continuing the present petitioner, Bangshidhar Pradhan, and his driver, for which an application under section.
I oppose this, man. What is this observation driver?
Oh, 1 minute. Yes.
That I can prove. Let it come, my lord. I will give evidence that he is belong to Athagar and he is the
But
driver
we
of that
did not
person
go
who
into all
resides
this.
in Bhubaneswar.
Now the fact remains.
Now,
that-
now I am coming along.
Yes.
Then an application by these petitioners and some others were filed under section 92 along with a plaint for removal of the trustees and management of the institution. District judge, after hearing the parties, granted leave and the suit was registered.
92 suit page pending.
I am coming to that. Then 92 is the leave.
The leave is granted.
Granted and suit is
Yes.
registered.
Right.
Challenging that a revision CRP 3 of some order was filed before this honorable court.
Against the leave order.
Yes, then that was dismissed by Honorable Justice K.R. Mahapatra. And that has been challenged in Supreme Court by this Bangshidhar Mahapatra, a Bangshidhar Pradhan, and that is pending. And stage of the suit is there. So in this scenario, case and counter case, after and furthermore, you also may kindly see the affair he lodged. The affair was
Basically, long and short of the issue is you are against the trustee is against you.
yes,
That's the long and short of it.
yes, my lord, yes, and case and counter case.
You filed a case against the trustees and
Alleging
trustees have filed a case.
12
against
to
you.
15 crores.
And what happened to the case which you have filed, whether they are on bail?
Just after cognizance, they have come rushed here and they have obtained this stay. That I have given, my lord, also. That is the CRLMC.
This one.
Yes, for quashing the cognizance.
Now it is being stayed.
Yes,
Who is, am I the party to that proceeding?
my lord.
I am the party to that proceeding?
No, my lord, no. I do not know, my lord, but it is in 20.
If I am party, to just verify in this CRLMC, if I am the party, I will not entity, I will not deal with this.
And furthermore, another thing, my lord.
Let's see, who has passed the order in CRLMC?
Your lordship is not.
I have not passed?
No. Your lordship is not. So,
So my submission
That
is,
will be, if I am dealing with the cross case where I have stayed it, I can't deal it.
My lord, if my senior has completed, I will answer.
Yes, yes, okay.
now your lordship mechanism page 13. The affair was registered under section 417, 420, 506, 34. Final report was submitted therein. But on protest petition,
By the
40
way, who are you? You are the employee of the institution
yes,
run by the trustee.
yes,
The
madam.
trustee
But the
has-
trustee is not interested to run the institution.
But trustee is wrong or right? Trustee is still continuing.
No, my lord, trust
There is
not continuing. He has closed down the
92 leave is granted.
No,
and-
my lord, you also can appreciate, he has closed down the institution. He has removed 21 teaching staffs illegally, though they have served for more than 11 years. There and he is sitting in Bhubaneswar. Thereafter, everything is in the final report, my lord. And in the final report, he told that he has misappropriated 15 crores. In the final report. And furthermore, my lord, to run the institution on resolution of
But
the
how can you are being employed? How can you run the institution?
because my lord, students are admitted. Future
That
of
is
the
the
students.
outlook of the institution.
But
You are the employee, you are the paid
But
employee.
with some,
Why are you so interested
my lord,
in
with
running
some
the
of the
institution?
outgoing trustees, the institution is running.
That's the old difficulty. There is a.
My lord, that
It is
Anyway,
very
that-
difficult.
my lord,
Anyway, that's.
It-
Now,
that-
long your rightly bail has been granted, my lord.
that was,
Lord-
that is to be argued.
Bail
granted, no problem.
Sikiri.
Now, I'm just looking at the file on the perspective that if the bail condition could be altered, because without any condition, without anything, straight away bail is granted to you. So, ideally speaking, there should be.
Then my lord,
in
your
this
lordship
kind
kindly give me some time. How the amount has been, now question, your lordship is value area in a case of 409. Once entrustment is proved, then how it is That I have to say.
You
Now I will show
Sir,
your
you tell me one thing. Trustee is running the institution.
my lord.
Mismanaged, whatever, he taken money, whatever. You are the employees. You have been attempting to throw the trustee out by filing a 92 suit, got leave of the court. And they don't want that you should continue the institution because you are the employee. How can you take away the institution being an employee?
No, my lord, we are running the
I can
institution, not
understand.
that
Why should
because he is not cooperating. He
that
is
is there,
misappropriating everything.
that is the problem of the trustee.
So-
Interested trustee,
so
I
I
can
will
understand.
submit
If
my-
you would have been a trustee, I can understand. How can you maintain an account and
Because
withdraw the money?
one of
being
the
an employee-
principal in charge, principal and resolution they have been appointed to operate the bank account.
Who has authorized you to open an account?
By a resolution, the teaching staff and non-teaching staff and some other
Ah,
outside.
is
outgoing
a
trustees.
institution run by the trustee, you pass a resolution, open an account, get the
but
get the
that-
amount deposited, withdraw and disburse. What
But
is
that
this?
is a civil dispute matter. No criminality can be
Sir,
attributed
there
to
is
that.
there is
And
some.
now I will
I'm
submit, my
examining-
lord.
you seek instruction how much you deposit.
My lord,
It is wrong or right? It is the institution run by the trustees.
my lord,
You
your
are the
lordship,
employee.
I will
You had no authority to open an account, take money from
we have
institution,
not
students,
misappropriated a single pie,
deposit
my
it
lord.
and withdraw it. All these things.
No, my lord, we have not misappropriated a single pie. Everything has been
Might
paid
be.
as salary to the teaching and non-teaching staffs. That I will
But
submit,
what
my lord.
authority you have?
My lord, that is a matter going on.
So therefore,
That is not a criminal matter.
I am not deciding that. What I am saying, I am trying to find out a way that if money is misappropriated to
Not misappropriated, my lord. Not a single pie.
you might have given salary. You want to run the institution, no problem. You run the institution.
But to
In the
run the
interest of the
institution, my lord, to run the institution, start teaching and nothing has to be
Required.
paid. From that amount they have been paid.
That's right. That's right. But they say that this amount is misappropriated. To strike a balance, how much you deposit as a bail condition, you tell me simple. I am not interfering anywhere. I am not cancelling your bail. I will not cancel.
Then I
your
have to
bail.
take instruction,
Yes.
my lord, and I will file the
Deposit,
papers, my lord.
deposit something.
I am unable to deposit.
One thing I'll say. This,
I will not cancel the bail.
no, I'm,
You argue whatever.
my lord, I'm not seeking cancellation. Let the money be secured. This much I want. Money has to be secured because it is admittedly institutions.
But he wrong, right? Whatever. The institution is being run by them,
Kindly.
taken over by from you and run by them. Students are
No, it
continuing.
is not a fact. Institution was closed since 2016 due to deficiency in not complying the AICT norms. Thereafter,
Where the students are reading.
students have not come up after 2016. They have admitted students in a closed institution, taken money and opened an account. This Sukant Manti was removed from service, filed a writ application dismissed. He now says, I'm in principal.
What are you
lecture."
doing, by the way? Who are you?
I'm the trustee, my lord, founder
But
trustee.
otherwise, what are you?
My lord, I'm founder trustee cum chairman.
What are you doing otherwise?
I have two other institutions. I run institution, engineering, nursing colleges, I'm running. My lord, your lordship will page 38. It is opened by Sukant Manti, Saurabh
I
Chandra,
understand it.
Surat
That's what
Rao.
I'm asking.
My lord, what authority they have to open an account?
That
And
is
if they have opened account, they have deposited 2 crores 85 lakhs, withdrawn 2 crores 75 lakhs. My lord, if your lordship secures that money and they can prove in the trial court that no, we have not taken money, they'll be acquitted. I don't say that this money should come to me. I say it should be secured.
During in the investigation, whether the police has resort to 102 and freeze the account?
My lord, that is 10 lakhs now. Now this 10 lakhs is also gone. This 10 lakhs is also gone. What will be there to freeze, my lord?
Police should have freeze this account.
Yes, he did
Under
not
102.
He did not freeze it.
For that reason, my lord, I wanted to take a lordship to the charge sheet submitted by them. Detailed inquiry has been conducted.
My
Detailed
lord,
inquiry.
that's a protest petition. Court has
Maybe.
taken cognizance.
Anyway.
Prima facie, that's
to
a
seek
cognizance.
instruction, let us
My lord,
balance it.
my lord, I cannot deposit the money. Your lordship may cancel or whatever it may be, but I am unable to deposit because we have not misappropriated. We have paid it to the teaching and non-teaching staff towards the salary and other expenses. That expenses, bill and other things, I want to submit before lordship.
My lord, can
And
your
how
lordship
he has
decide it?
misappropriated.
My lord, can
There
your
is bank
lordship decide
account.
it?
My- your lordship-
I am not conducting a trial.
No, my lord, your lordship may kindly see. Because of the dispute, by the order of this honorable court, the collector on board was appointed as the person to manage the institution, and the collector directed the Tahsildar concerned to manage the institution. Then thereafter, since 2000, by beginning of 2000, he closed the institution. And the
now institution is closed.
No, my lord, it is running well.
No, it is closed. It is closed. My lord,
And-
collector was appointed in during when the dispute between trustees came up in second appeal. Second appeal I won, went in apex court SLP dismissed. Collector handed over me charge. When I handed over the charge and the institution was running, these persons threw me out of the institution, did not allow me to enter, opened an account and took the money.
Have you filed a response, sir?
No, my lord, I will file a
You
response.
file it.
Giving the.
My lord, once they said they cannot deposit money, your lordship may pass appropriate orders, whatever your
I'll do
lordship.
that.
My lord, nothing remains to be decided because my senior has candidly admitted that we cannot deposit.
Why don't you settle this? Institution is ruined
My lord,
because of the infight between.
they will not. My lord, once there is 2 crores misappropriation, what will do money? They have opened the account and taken money, and this is all recorded. It's a bank statement. I have not created a statement. And once they say they will not deposit, your lordship may pass
Further,
appropriate orders. There is nothing to be filing of response because your lordship will not decide whether the accounts are correct or not, whether the payment has been made, because your lordship is not a trial court. That will be decided by the trial.
Okay.
And once in the cancellation
Let him file response.
my lord, what response? They are not ready to pay money. They are saying that they are not
See,
ready.
right, wrong, whatever, there is a protection order in their favor. And if any order is passed, it will affect them. So they are entitled to file reply.
My lord, question is, I am not on cancellation, but I am on that this misappropriation is there. The magistrate, whether he has a power under 437 to grant bail. Secondly,
Then I'll dispose it up with an observation that trial court will impose appropriate condition. Yes,
yes,
the condition is
yes.
there is no condition.
Yes, that your lordship must in view of the Supreme Court judgment. That will do, my lord.
Let me file a response to the.
Wednesday. Keep it Wednesday. There I'll dispose it up saying that the trial court
Furthermore, I
without
have filed
imposing
an
any
application
condition
for quasi
has
judicial convenience.
granted bail. So therefore, matter is remanded to impose appropriate condition.
My lord, even
In
if
accordance
any
with-
number of documents I filed, my lord, can your lordship interfere on those documents?
Let us see. Let him
Because your lordship is not conducting the trial.
Wednesday. You please file.
I have filed also a CRLMC to quashing the order of cognizance. That is pending.
Yes, next.
Item 12.
Yes. Non-APA.
Modification of change order. My lord, the modification of order passed by the trial court, my lord. Trial court has passed the order that the petitioner she shall appear in the court each date of appearing.
But nobody appeared last occasion also.
Yes, my
Right. When the matter was, this is the petition seeking petition under section. Where is the section 439(1) bracket small b CRPC for seeking modification of condition number 2 of the order dated 23/11/2023 passed in GR case number 145 of 2020 passed by JMFC cognizance Roman 4 Kotak. Roman 4 Kotak. Where is the impin order? Where is the impin order? What is the condition? Which condition is talking about? Condition number? Condition number? He shall appear before the court on
Before
each
the
date.
court in each date posting, my lord. Because the FIR is great, my lord, but there is the 14 lakh, some order has been misappropriated.
When the matter was taken up, which item is this? Item? 12, no? None appeared, when the matter was taken up on 2/4/2024, none appeared on behalf of the petitioner.
It is third time, my lord, continuously not
Uh,
happened.
non-appear for the petitioner. It appears the petitioner is not interested to proceed with the case, hence the petition is dismissed. Yes.
Item 13,
My lord, dismiss.
My pleasures.
Yes, sir.
That extension of time, you know, sir.
Huh?
That petitioner, in right time not surrender in that court, he was
Speak little louder.
that order to petition right in 15 June surrender in that court and put STGM Barampur, but that petitioner has not surrendered in right time. Due to festive accident, that petitioner has not surrendered in right time.
That
He was it-
I couldn't follow you anything. What exactly you want to tell?
Extension of time.
extension of time, you know, sir.
Extension of time you need.
Yes, yes.
Because I had given you time up till
कितने तारीख दिया था?
15th June
15 June.
24. You couldn't take,
No.
why?
Yes, the petitioner has faced a road accident.
Okay, you want extension.
Yes.
Right on. Then counsel for the petitioner submits that by the order dated 14/5/2024, the petitioner was directed to surrender before the court on or before 15th June 2024 and seek appropriate remedy under law. Till then, the execution of NVW issued against him was stayed. However, the petitioner met with an road accident, as a result of which he could not appear before the court. Therefore, he seeks extension of time. How much time?
In 2 weeks.
Huh?
Within 2 weeks.
Till today is
21 June.
huh?
21 June.
21st, 15th July. Okay?
Hopefully,
Good,
sir.
good. Make it 25th July so that you will not come once again. 25th July.
14,
My lord, there is a typographical error in the order your lordship passed on 15/2024.
Where, what is that?
Para 3,
Yes.
line 2, 22/12/2024. That may be corrected as 22/1/24.
By see, eko. Do you extra like that?
Hey, lagi.
Typing the problem is, yeah?
I would para 5 hojur, line 2, 22/1/24. It I push 2024.
अरे कुछ बोले तो पारा 3 रे 22/1/2024 হবো সেকেন্ড লাইন রে 22/12 লেখা হইব ঠিক আছে আর 5 রে 21/2 জায়গায় কোন হবো
22/1/24.
22/1 22 ঠিক আছে কেয়ারফুলি করিব
Time of extension. 30 June পর্যন্ত।
In view of the aforementioned confusion, the petitioner could not appear before court as has been directed by this court by the order dated 15/5/2024. Therefore, he seeks extension of time. Accordingly, the time is extended up till 15th of July. 15th of July, the petitioner is directed to surrender oblique appear before the court below on or before 15th July and seek appropriate remedy available to him.
15,
May I please, my lord?
Yes, sir.
The vigilance case. The order of attachment proceeding has been passed, but in the meantime, the sole appellant who was first trial, he has expired and the proceeding has been abated against in main trial. So the petitioners are the legal heirs of the deceased persons. They want to continue the appeal and to set aside the order passed by the London Judge.
Right.
The vigilance senior standing counsel, Mr. Das is absent.
May I pray for a Passover notes? One Passover notes, I informed us.
Monday.
Aku weekly
Monday.
Weekly. Monday weekly.
I mean, pardon, I have some personal difficulty.
It's all right, weekly.
And another prayer mail. No, your examination is going on. Another hearing is was one week after because one death reference is parted. It will continue from Monday.
Yeah, when it will be called, you just tell me, I will accommodate.
52.
52 also weekly list पे पकड़ दो.
Right.
हाँ. Oh, 52. Yes.
I will inform you.
Ready. 15th. What is that withdrawal memo?
Which one?
Let it be there. No problem. Yes.
My lord,
Yes.
this matter will fix to next 5 days. So that we'll file our written notes and submission, short written notes.
You
and-
file written note of submission. I am putting it in the weekly list.
Yes, ma'am.
He has a death reference. Whenever it will come, subject to his presence, we'll do it.
Yes.
Next, 16.
16, if lordship permits, lords, though the case is listed under the heading orders, but in fact, defects have not been removed, but this revision has been preferred against an orders rejecting a discharge application. If lordship turn to the page 16 of lordship reports, after rejection of the
Hey, this-
discharge application, case was posted for framing of charge way back in 2009, 19 to 2009. Page 16 may kindly glance through.
Right.
please.
The present petition is filed,
Challenging an order,
challenging an order dated
order dated 19,
19/1/2009, passed by the Special Judge Vigilance, Baleshwar, in TR case number 438 of 2007,
rejecting a
whereby-
discharge application.
whereby the application of the petitioner
To be
seeking
discharged.
discharge has been rejected. The present petition was filed when?
Way back in 2009.
Present petition was filed way back in 2009. When the matter was taken up on 9/4/2024, none appeared for the petitioner.
No, the defects are
Not
indicated.
appeared for the petitioner. Despite that, the coordinate bench of this court has granted liberty to the petitioner to cure the defects pointed out by the registry.
Despite that.
When the matter is taken up today, none appears. The defects pointed out by the registry has also not been cured.
The input note
Land
also
Council-
indicates
Mr.
date.
Das, Land Council petitioner submits that
No, no, that's
the
the
charge has
state
already been
residence.
framed.
No. The case had, the input order indicates on 19/2/2009, the case was posted for consideration of charge.
This matter, Mr. Das, Land Council for the petitioner,
The
opposite
state
party,
vigilance.
the state submits that the case was posted for framing of charge on
On 19/2/2009,
in 2009, and
in the absence of any interim orders.
since there is no interim order in the present case, charge might have been framed by now, and the trial must be proceeding. In view thereof, nothing survives in this matter. Accordingly, the petition is dismissed.
Reproduction.
Next.
Item 17.
17, my lord. I have taken instruction, my lord. There was a settlement between the parties, my lord. Hence, the petitioner does not want to press the application. Previous counsel, my lord.
Lordship, I am for the council.
Yes.
Uh,
You have settled.
Lordship, they have
Alrighty.
told in orally.
Sorry,
They have, the petitioner has told in orally.
told in
Told me, us to
orally he has
only-
informed you
Yes.
that they have settled the dispute. I'll
Yes.
record it and dispose it up. If anything happens, then
Not-
Land Council for the petitioners, Land Council for the parties jointly submits that the matter has already been settled. The present matter is arising out of a dispute under section 138.
138.
138 NIA.
NIA.
NIA. In view of the fact that matter is stated to have been settled, nothing survives in the matter. Accordingly, it is disposed.
Okay.
18.
May I please, your lordship. 18 laws is today for listed for orders in the matter of limitation, lords. Lords.
Sorry.
Item 18, lords. Today the case is listed for orders in the matter of limitation.
There in trial court.
No, my lord, in this case, we have filed, this revision has been preferred by the state lords against an orders by which the opposite party, Ramchandra Jena, was the peon was discharged in a trap case.
Okay.
So we have preferred this, state has, vigilance has preferred this revision,
Mm.
and an application for limitation has been filed. and notice has been issued. Now, today is listed for the
Condemnation of
orders.
delay, yes.
For condemnation of delay. Only 3 days only, notes.
3 days, delay condone, release the matter, have you filed IA?
Yes, my lord. The application is, my lords, miss case number 574 at flag A notes.
574. Yes, 574. For the reasons stated in the application is allowed. Delay in preferring the revision petition is condoned. And what about the merits?
Merits, my lords, lordship fix a date to Monday or any day, or otherwise I am ready also. Lords. In fact, in a trap case, my lords, two accused persons, my lords, that
at least 2 weeks time may be given because for 7 years I have appeared, thereafter I have no contact.
No, it's a case of discharge 2012.
Yes.
It is a well considered judgment.
And in fact, it's an interesting case involved in this case. In a trap case, tainted money was received from the present opposite party, the peon Ramchandra Jena. He received it and he said that I received rupees 300 from the informant as per the instruction of the co-accused Haribandhu Sao. Haribandhu Sao preferred a 482 application in the High Court notes, and that was quashed notes. And my lord, no order has been passed.
What is this judgment 9?
Yes, that Haribandhu, main accused, has approached this honorable courts. And this honorable court, because the money was not recovered from him, this honorable court allowed the application notes. And nowhere is it High Court as the honorable court, your lordship can turn to that High Court order has been, we have annexed, my lords. That order dated 9/10/2013. That's a case filed by Haribandhu Sao, the person who did the demarcation. He filed an application before the Tahsildar Badbali, and that this Haribandhu Sao was the person who demarcated it, and the peon attached to him is the Ramachandra Jena, who is the opposite party in this case. Now the money was the tainted money was received by the present peon, the Ramachandra Jena, my lords, at the instance of the main accused, that Haribandhu, lords.
Haribandhu has been discharged.
Haribandhu has been discharged, saying that no tainted money was recovered from him. But the Ram Jena peon attached.
Suppose you succeed, how will you secure conviction? Have you challenged this order?
In the meantime, the latest judgment Supreme Court said.
Forget our judgment.
My lords.
Have you challenged the order of this court discharging this Haribandhu? Haribandhu Sahu,
you have not clinching the issue, correct?
You have not challenged that. That order stays on the face of record.
I'll just inform.
In the face of this order, even if I have allowed your revision petition, can you secure a conviction?
The other person who received and from whom they
forget everything. These findings of this court, while discharging one of the co-accused person, will keep on staring on the face of record. On the basis of that, can you secure conviction of any co-accused person in this case?
No, this
so why should the entire process should go on once again? You have not challenged this order. You should have challenged this order, upset the findings.
Yes, on that, my lords, I will just, this is a case of 2012, my lords. We have filed it. My lords, I will just take instruction what lordship is clinching the issue, whether any case has been filed challenging that order.
Simply seek instruction. Otherwise, this is an useless exercise.
Agreed, my lords.
And burdening the trial court.
Agreed, my lords.
Unnecessary to,
Agreed, my lords.
This is the simple issue.
Yeah, your lordship clinching the issue. I agree.
I'll put it at Monday. You come with instruction.
My lords,
better advise your client not.
This is a instruction. I'll get it from Kenjor. Some breathing times of 2-3 days. Not be Monday.
Let it be Thursday. Friday. Okay. Friday. You advise your client not to press this kind of petition. Unnecessary discharge, long vacancy.
When this case was filed, I was not in this one, but it was filed.
This will be the biggest problem.
Yes, I will get the instruction whether the other person who has been let off, whether any petition is filed, challenge that order. So let's correct. I'll get it.
Or otherwise, you should have filed a SLP and got an observation that the findings recorded by this court while discharging the co-accused shall not bind on the trial court while trying the other co-accused. That kind of observation would have been there, I can understand. Otherwise, it is binding.
And I will also consider if the lordship has given me an escape route, if I can satisfy to lordship, breadth of this particular, the main, the accused persons, my lord, who did the demarcation acts as peon, who is the opposite party in this present
The chain
case.
is broken.
I'll just,
Chain is broken. He is in between.
You lost
Haribantu Sahu is in between. He goes out. Then chain is broken. How will you secure a conviction?
The other person, my lord, who received at the instance of the main person, my lords, that the tainted money was recovered from him, that's admitted on records, my lords. My lord, I'll just explore the feasibility. I don't say that.
Friday.
Friday.
Friday. Advise your client not to proceed. That's a fair way of doing it.
Yeah, my lord, my lord, I'll come back to lordship with positive instruction, lords.
Yes.
Item 19.
My lord, item 18, lordship fix a date, my lords.
Friday?
28.
Yes, sir.
As item 19, the list yesterday, I found is appearing for the bank. Case of NI Act, check up our amount for 72,000. Now the 1 lakh compensation has been awarded. At the time of revision was filed.
You are for
I'm
accused.
for the accused. For filing of revision, he was in custody. Let me, I would take 2 weeks time.
Custody in this case.
He was there. The revision was filed and was granted bail by the Supreme Court.
Hmm.
Let's say after 10 years it has come. So let me grant 2 weeks time to take instruction regarding payment of the that amount.
Principal check amount is
72,000.
75.
72.
72.
Compensation
Compensation
1 lakh.
is
1 lakh.
1 lakh?
Only simple 1 lakh.
1 lakh.
Only.
And how many days you have gone in jail?
He was arrested on 1/7/14
Hmm.
and released on bail on 26/7/14.
1/7/26/7.
26/7.
About 7 days. Huh? 7 days?
Right.
About 7 days. What is your answer?
Here, my lord, before
You are a bank.
I'm the bank, my lord, but in the meantime, since 2010, the account has been assigned to Kotak Mahindra Bank. So for the updating the account records, my lord, in the Kotak Mahindra being made a party, he may be directed to at Kotak Mahindra Bank as a party. It has been assigned there by virtue of an assignment agreement.
Why should he will bring?
He has filed the revision. I am giving the address
ICICI
detail.
Bank was party.
ICICI Bank has initiated.
Application. Why should he bring? You have prosecuted him.
Well, yes, but no revision. He can change the.
Who has prosecuted him?
In
ICICI Bank.
complaint I have
prosecuted
filed.
him. ICICI Bank
I
is
can
now
file-
given
I
it to Kodak.
Kotak Mahindra.
Kodak should come and say that, see, I have taken over.
My lord, I will take step accordingly.
Otherwise, I will allow it and let him be out.
No, well, I will take step. I have also taken instruction from Kotak to appear also.
Obviously, he is an accused.
Yes,
My
madam.
lord.
Prosecuted by you.
My lord.
Why should he keep on searching?
No. I am giving the detail. He has to make an
No,
application.
you.
I don't know.
Kodak Mahindra should come and application.
Yes,
do an application.
I'll file an
Instead of ICICI Bank, I will prosecute him.
My lord, I'll.
Otherwise, there is no prosecutor for him. I'll simply allow it.
The company is close to
No,
the
no.
bank.
Do it by next week. Otherwise,
My lord, I will text.
allow this and satisfy.
I'll text him.
Because he can't search his prosecutor.
Exactly.
And he is free now. Because ICICI Bank is not interested. I'll allow it.
Bank में अच्छे रहे bank
Bank को assign कर दीजिए. Kotak Mahindra will step in. I have taken.
For this, the assignee has to come and say.
My lord.
If assignee doesn't come forward,
My lord. In fact, I
then
have.
he is free.
Yesterday, I have talked to the Kotak Mahindra. Also, I am panel lawyer for Kotak Mahindra. I have taken instruction about the outstanding also. My lord.
Do one thing. You seek instruction.
My lord.
Sending him to jail will
No
cut
purpose.
no eyes. As it is 7 days, he has already gone. 72,000 rupees. He will pay 72. No problem. Forget about the compensation.
No, my lord, I am on the other way. Lordship is correct. But here, my lord, the account, the vehicle is remains with you till date. The account standing with the outstanding of rupees 5,20,000. I have instruction that on principal basis, the account can be settled. If we can take instruction on that way also. On principal, that is coming around 3,20,000.
Principal कितने?
3,20,000. Principal amount.
Oh.
2 lakhs we are waiving out.
No.
How can you
No. He had taken loan of 3 lakhs or something.
3
3 lakh
Mile.
and purchase a car.
My lord.
He might have given installments. to you.
Some installment,
And
that
one
detail I can also have.
72,000 installment, he could not pay.
Take amount
Therefore,
for it.
you prosecuted him.
Yes. My lord.
Today you can't recover the entire
Yes.
amount which he has already paid. You think of the check amount.
Okay.
Think of the check amount.
I'll also.
Try to be fair. You get some money and. better
I am
that-
also, that is correct, my lord. I am also thinking of.
And the conviction is confirmed by the appellate court. Therefore, the present revision is filed. I've heard both the parties at length. I am of the considered view that the matter could be settled on mediation. Therefore, the parties are relegated to the Odisha High Court Mediation Center. Shall I fix a date?
Well,
Tuesday.
They will fix the notice and they will fix the date of appearance.
Why I'll fix a date and.
any date, lord, fix any
You tell me
Friday.
the date.
Any Friday, lord.
The parties are directed to appear before the court, appear before the mediation center, the Odisha High Court Mediation Center on 28th of June 2024.
Granting more sometime.
Again, let it be 5 or 12, my
Yes,
lord.
yes.
5 or 12.
5 July, and explore the possibility of settlement, awaiting the mediation report, lease the matter on 10th of July. 10th?
End of July.
10th July? 10th July. In one sitting, it will be over.
In the meantime, also, I will try to
Take money, whatever he is paying.
exactly. In the meantime, Kotak Mahindra will also step in, will file the application.
Better let counsel for the opposite party, ICICI Bank Limited submits that meanwhile, this account has already been assigned to Kotak Mahindra
Kotak
Bank,
Mahindra.
and he seeks permission from this court, permission of the court that the Kotak Mahindra Bank should be permitted, should be allowed to participate in the mediation process. Accordingly, the oral prayer made by the opposite party is allowed, and Kotak Mahindra Bank is allowed to participate in the mediation process. Everything is over.
20.
Item 20, my lord friend appears for the petitioner. But before I say something, lord, so my item 20 pertains to an orders by which he may file an application under section 457 CRPC for release of check books and ATM cards in a disproportionate case, lords. That application has been rejected. He preferred this revision in 2014, lords. My learned friends has lost his brief, so also I don't have the copy of it. So what I suggest to my learned friends,
I'll allow it. That's the best thing.
So why I say so, Lord?
You will be free. You will be free.
Let him get a.
Now, why are you holding his checkbooks and all?
No, in the meantime, lords,
What has happened also, I'm contacting the client. Let it come there. In the meantime, I will give a pen drive kindly.
Yes, of course.
That's
There is
the
no
soft
problem.
copy, maybe.
Your junior is there. Come and take
Man.
and give a copy to.
No, that is agreements also.
Most of like.
I'll put it on next week. Pen drive, you take it, huh?
Man.
And get a printout and give him.
But I share this particular advantage your lordship has given. Doing that, this
I did not know. My learned senior has told me. I'll get a copy and give you a copy also. He also has lost the copy.
Next week anytime.
Wednesday.
Wednesday. Yes.
Date.
26. 26.
And seek instruction also. Why are you holding his checkbook?
I also think what has happened. In the meantime, I'll contact the client.
May not be the checkbook might
have
not
to
be
also
required to you also.
Yes.
What will you do with that checkbook? Old checkbooks. Yes.
22.
Before item 22, item 18, the limitation was allowed. Notes. Item 18, that limitation case was allowed. Thereafter, lordship fix a date. Notes.
Yes. Yes, sir.
I have deposited an amount of 42,000 in slip of check. And in the meantime, the conviction was sustained by this honorable court, and I have NI Act. And in Supreme Court, I have paid 60,000 and it has been settled. I want this 43,000 to be withdrawn in my favor.
What had happened? You have deposited what?
43,000 by safe of and check. and that has been withdrawn by this honorable registrar.
No, this is a case arising out of 138.
138.
Yes, what happened? You are the accused,
I am the accused.
right?
I have deposited 43,000 the check amount,
Check amount, yes.
and my revision was disallowed, and I went up to Supreme Court, and in Supreme Court it has been, apex court, it has been settled by the parties, and I paid the money. Now I want that.
The money which is deposited here to be
Here I
released.
think
That's what you want.
released
Where is
by-
the Supreme Court order? Show me.
Yes, yes.
Show me. During the pendency of this revision petition, you have filed.
I have deposited a
deposit-
check of amount 43,000 on 14/11/2022.
Thereafter,
And 15, it has been withdrawn by this, by the registrar. That was deposited by the registrar, and amount has been withdrawn by
during the pendency of the revision petition, you have deposited
43,000.
Okay. And the revision petition is dismissed eventually.
Dismissed.
And the money was lying here.
Lying.
And you went to Supreme Court.
Yes.
Supreme Court, in the Supreme Court, you have settled the dispute.
Yes.
Paid 60,000 rupees.
Yes.
So that 43,000 rupees which you have deposited is lying in the registry,
Yes.
which you want to release.
Yes.
That's what you want.
Yes. Yes.
You tell me the
Which-
date when the revision petition was dismissed. When was it dismissed?
Yes. Yes. (28/3/2023).
28?
28/3/2023.
20, right now. The present revision petition has been filed by the petitioner challenging the order dated 26/7/2012 passed by the additional district and session judge Adka Ganjam in criminal appeal number 20 of 2014, whereby the conviction and sentence passed against the petitioner for offence under section 138 NI Act by the court below, by the court of JMFC ASCA has been upheld. During the pendency of the present revision petition, petitioner was directed to deposit 43,000 rupees. But eventually, the present revision and subsequently, the petitioner has deposited the said amount, which is lying deposited in which bank? Lying deposited in the registry of this court. Registry of this court. So, eventually, the present revision petition was dismissed by this court by order dated 28/3/2023. The petitioner assailed the said order dated 28/3/2023 by filing SLP bracket criminal number 5409-5410 of 2024. The Honorable Supreme Court allowed the SLP on 15/4/2024 on the ground of settlement. The present petitioner had paid rupees 60,000 to the satisfaction of the opposite party before the Honorable Supreme Court, and accordingly the appeal filed by the petitioner before the Supreme Court was allowed. The petitioner has next paragraph. The petitioner has now moved an application. Have you moved an application now?
Yes.
Which application is that?
That is IA
Where the petitioner has now moved an application under application IA number
392
of 2024, seeking release of the amount lying deposited before this court. In view of the aforementioned development unfolded in the present case, the application is allowed. The registry is directed to release rupees 43,000 and any interest accrued therein in favor of the petitioner within 15 days hence. Disposal.
One last I may permit to withdraw my lord.
Next item.
My lord, client has taken brief from me.
Give,
Yes, sir.
check amount is. And your lordship is directed while granting bail to deposit the installment before the court below. And this person is aged about 64 years.
15,000 only.
15,000.
Who is the complainant?
Complainant is the opposite party not true in this case.
He is appearing.
Appearing.
Anant Kumar Mahapatra.
Huh?
Mr. Anant Kumar Mahapatra only and associates.
What is the compensation amount?
20,000.
20,000. Call him. I'll dispose it of right now. Be ready to pay another 5,000 rupees and rupees.
10,000 ଦେଇଛି ଆଉ
10,000 pay 5,000 rupees and persuade.
ତାର ବି ଅବସ୍ଥା ନାହିଁ ଆଉ ସେ ଲୋକର
5,000 ଦେଇ ଖତମ କରିଦବ।
ଆଜ୍ଞା
ବର୍ତ୍ତମାନ ଖତମ କରିଦବ।
ତାଙ୍କୁ ପାଇବା ବହୁତ ମୁସ୍କିଲ ହେବ ଅନ୍ତ ହେଇ ବସିଛୁ
ଡାକି ଆଣନ୍ତୁ ଯେତେବେଳେ ଆସିବେ ଆପଣ
ସରିଯିବ ଦେଖୁଛୁ
5,000 ଟଙ୍କା ଦିଅନ୍ତୁ ଖତମ କରିବେ କଣ
ସିଏ ବି ଆସୁନଥିବ
if you will not willing to take it then I'll allow your petition. He has to be satisfied with 10,000. Okay. Pass it over. 35. Katola payment come.
गोपी की डाकी गोपी की डाकी
Yes.
May I please, my lord, your conviction is for 5 years.
25. 25, na?
Yes, my lord.
Yes, sir.
I pray whether I will be granted the deposition copy that is not with me. I would
What is the offense?
394
କିଛି evidence ଅଛି?
No, my lord.
Trial court judgment वगैरह पढ़ले କିଛି evidence ଅଛି? केवल conviction है।
My lord, copy of
In the year
deposition.
conviction is 2013.
My lord.
What was your age that time? You were 29.
My lord.
ये weekly take LCR has come.
My lord.
In the pen drive you take the.
My lord. My lord.
Okay.
Pen drive later.
Okay.
Okay.
26. Yes, sir.
26 on behalf of AK Sahu, he is instructed that the file has been misplaced. Some time is required to restore his.
What is this case?
I do.
2004. ठीक है?
26.
नहीं 2004
2014.
Offense is 307. 30734. So reconstruct the file.
Pardon me?
Reconstruct
Yes,
the
ma'am.
file. 2 weeks for the let consider the petitioner submits that he has lost his file and want to reconstruct the file. Therefore, he seeks 2 weeks time. Accordingly, 2 weeks time is granted for petitioner to reconstruct the file and file a written submission, not exceeding 10 pages.
Yep.
Yes. 20. 27. Yes, sir.
I am for the opposite party.
138 conviction, so followed by confirmation the appeal. That is before the
Check amount?
Against it, the petitioner is before. I am the opposite party. I am the complainant.
Check amount.
Check amount 1 lakh.
Has he deposited anything? Who is this? Who is the counsel? Huh?
Madam, we take it next week, giving last chance. Some reason.
Next week, procedure. 27th.
Last chance.
Non-APS for the petitioner. In the interest of Mr. Chand, APS for opposite party number 2. This the present case is arising out of conviction order.
Yes, 139.
Recorded against the petitioner, confirmed by the appellate court for offence under section 138 NA Act for the check of rupees
1 lakh.
Check of 1 lakh rupees. And compensation kete question?
1 lakh rupees. Said for a period of, they said 1 year and to pay amount of 60,000.
Leave the matter on second Thursday. Who is the counsel? His name is reflecting. Reflecting.
Their name is there.
Otherwise, I'll dismiss it next time. Yes.
28.
Yes. In this matter, I think the appellate court has
Remanded the matter
reversed
for
and
hearing them.
remanded, and there is a stay operating.
Yes.
From this court, 2011. to stay judge.
They have further proceedings that's in 8820.
So therefore, enjoying stay.
They have stayed there for the till he is not coming.
Who is the petitioner here? Petitioner is Kalia and Waji. Okay? And Kalia Waji. Petitioners were subjected to for trial for alleged offence under section 457/395 IPC and section 27 of Arms Act. The learned trial court, by the learned assistant sessions judge Hon'Ble, provide its judgment dated 29/9/2011. Have convicted the petitioner for the offences.
Both the petitioners.
Offenses. Both the offences. The whole clear evidence prosecution. The whole that is persons. convicted the petitioner for offences under section 457 of 394 IPC and section 27 of Arms Act and accordingly sentenced. The petitioners assailed the said conviction and sentence order by filing appeal before the Court of Additional Sessions Judge Nalgund by filing criminal appeal number 15 of 2011. The appellate court by its judgment dated 3/3/2014 have reversed the judgment of the declared trial court and remanded the matter back to the trial court to hear the matter afresh after examining the related magistrate who had conducted the TI period. Against the said judgment of the appellate court, the present revision petition has been filed. By the order dated 8/8/2014, this court had stayed the proceeding before the court below. As a result of which, even after remand of the matter by the appellate court way back in 2014, the trial is stalled. The present revision petition is pending since 2014. Next one. None appears for the petitioner. In the interest of justice, the matter is adjourned to next week of you, and it is made clear that if the petitioner doesn't appear on that day, the interim order passed by this court by the order dated 8/8/2014 shall be vacated.
Posted to
Next week. 29.
This revision is before.
Interim order vacate kale ashibe 14 since 2014.
10 years.
10 years. Yes.
The revision is against the order of conviction under section 380 and 457 of IPC. The case of the informant is that he is having a shop room at the FCI Chowk in the town of Fulwani, and at midnight somebody has break open the lock of the shop room and taken away all the properties inside the shop room. That is the allegation of the informant. Basing on
You is appearing, Mr. Dagada. Are you ready?
Basing upon the FIR, police has registered the case and investigated into the offense, alleged offense, and filed the charge sheet, and the petitioners has faced trial. In the trial,
Trial court convicted you.
trial court
For
convicted
offense under 457 and 380.
380 matter.
And sentenced to undergo RI of 1 year. And to fine of rupees 10,000.
Yes.
Okay. And what the appellate court does?
Appellate court confirmed that.
Yes.
So my
Tell me the star point.
point is that the prosecution has examined 7 witnesses.
Yes.
PW 1 to 4 are the independent witnesses.
PW
1 to 4 are the independent witnesses. And they became hostile. Informant is PW 5. The IO is PW 6. And PW 7 is the total 7 witness.
PW 7 is?
Constable accompanying the IO. Also seizure.
Seizure
Seizure witness. And out of PW one
Then
to
the entire prosecution rests on.
rest
three
on the
witnesses.
statement, evidence of the IO.
Entire the prosecution
Information.
rest on the leading to discovery 27 evidence act, my lord. Except that there are no such, my lord, evidence, my lord. What happened leading to discovery, my lord? The accused, my lord, the appellant, petitioner himself lead the police, Schedule 7 and Schedule 6, and gave recovery of the stolen articles, my lord. But though the confessional statement not admissible under law, with regard to
27 is it?
my lord. That
Why-
is there, my lord. For that is in my lord.
That's the conviction. That's how the
Yes.
conviction.
And that
Confessional statement in the
He
custody of the police.
First of
Your
all,
lordship know it is a weak piece of evidence. And
But if it's 27, then you're gone.
but
confessional part.
but the seizure witness
So far the leading, my lord, the
leading to discovery.
that is
But the witnesses who have been
That is close to the-
independent witness who have
What is the corroboration?
my lord, correct,
No.
my lord.
27.
hostile.
My lord,
All the
correct,
witnesses.
my lord, the article seized, my
If the
lord.
27 is there,
My lord.
in the absence of corroboration, can you safely convict someone?
No, my lord, that is not. My lord, what happened is, my lord, the confession under section 27 leading to discovery, my lord, that is not admissible, not, my lord. With regards to materials concerned, my lord, materials linked with this case, my lord, that is belongs to the informed, my lord. For that is non-court and appellate court convicted.
That
The
means
material
what,
question, my lord.
what you want to suggest is 27 is corroborated by informant.
My lord.
PW
No,
5.
Five.
No, no,
Five man
only-
identified
only-
that is has his materials and he is given taken this Jimanama, my lord. And so leading to discovery.
What are the materials?
TV and other household articles, my lord.
Okay.
PW, basing on the PW 6 evidence, the IO, the trial court has convicted the
Do
petitioner.
you have any judgment?
Yes.
Show me any judgment where it says that 27 alone can be made basis for conviction.
That is not, cannot be convicted, but
Without there being any
Corroboration.
the material seized, my lord, that is connected to
That's
the
the same thing you are saying.
Further.
What you are saying is
Further.
corroboration is drawn from PW 5. 27 is corroborated by PW
And
5.
also supported by PW 6 and also the PW
No,
5.
no. PW 6, 1 to 4. 1 to 4 are the seizure witnesses. Leading to discovery, they are the witnesses. They became hostile.
6 and 7 are the
Police personnel.
27 evidence.
My lord.
Yes.
Okay. And corroboration is 5.
Yes. Informal.
This is what is the whole case.
Yes.
And 1 to 4
Are the independent witness, seizure witnesses.
And show me any judgment which can land you support. Straight away come to that. I need not go into
One small point. Only material seized, my lord, that is belongs to the.
That's the problem. Get over that.
Only thing.
Yes, sir.
Para 9.6.
9.5?
9.6.
6, okay. The confessional statement of the accused and co-accused came to be recorded when they were in police custody. This court, so it had. For the application of section 27 of Evidence Act, the admissible portion of the confession has been found as to the fact which were immediately caused of the recovery. Only that part of the informant the rest. The statement is something new is discovered or recovered from the accused. Not belong to this is going against you only. Let's see, come to page 16. Para 13, reproduce. Mehboob judgment. 13, reproduce part. Read it.
25 and 27. That page 16.
Page 16, Mehboob judgment
Yes,
is
yes.
reproduced. Para 13. Read it.
For application of 27 of Evidence Act, admissible portion of confessional statement has to be found as to a fact which are the immediate cause of the discovery. Only that would be a part of legal evidence and not the rest. Let's see the evidence. What is the evidence?
27 is there already. Recovery is there.
Recovery is there, but
That is admissible.
let's see the statement. Your lordship says that the statement of the informant as well as IO is there in the record. Let's see what is the.
Are you doubting the recovery itself?
No, my lord. Recovery is.
What you want to say is, since he was in custody, his statement should be discarded.
That is one part. That is one part.
But if it is 27, it is.
27, but the seizure witness statement is to be taken into consideration.
Let us see.
If the materials
1 to 4.
if that is not linked with this case, then only case my lord.
No, to that extent, 13 says that if new material is recovered, that is also admissible. That's the problem. Yes. How the trial court is deals with.
Yes, ma'am. That part.
What is the sentence, by the way?
1 year.
1.
I'll give probation and finish it up.
Yes.
Why unnecessary
Yes.
traveling? I'll give probation.
The government employee, no?
Huh?
No, he not government.
Huh?
Not government employees. Petitioners are not government.
So why are you so unnecessary trouble? I'll give probation.
All right.
Section 4 probation.
Yes.
Probation. Rocky diyo probation. Section 4 likh diyo. Section 4. And write this judgment also. Keep it. Take it. Okay. Partly allowed. Yes.
Item 30.
30. A senior is waiting. Wait. Sorry, sir. 44. Please wait. I'll please wait, sir.
I'm waiting.
44. Yes, sir.
The petitioner has been convicted under 332 and sentenced for 8 months. And the fact of the case is that when Vijay Kumar, range officer of Sapanapur, while going, he found that the two accused persons are taking 10 sal planks bicycle, and they were detected, and this accused scolded him and stated that it is scolded me and threatened him. For that, they have filed this case, and the evidence was given. 6 evidence were given. My only point before this honorable court would be that in the judgment in para 8 to 10, the trial court has acquitted from all sections, but convicted on 332. But I am just reading one para. From the above discussion, it is found that prosecution has faced.
Which paragraph you are reading?
11, trial court.
Para 11.
Oh, yeah.
Yes, from the above.
From the above discussion, it is found that prosecution has failed to prove the offence under 331, 294, 506, 34 against the accused persons. But prosecution has successfully proved the offence 332, 34 IPC against the accused person. Both the accused persons are committed offence on 332 and 37. My humble submission, for this 332, there is no separate charge made, and nothing was asked under 331 to the accused person. That he is a government servant, that you have you are threatened to assault him, that has not been done. That has been reflected in the appellate court judgment. I'm just placing. That is the only one. Appellate court judgment in in para 5. I have raised this question.
Para 5,
Para 5 of the judgment.
appellate court.
Today. I have raised this question. Secondly,
1 minute.
the
Para 5, yes.
second para.
Yes.
Secondly, the charge under separate heads is not prepared by the learned trial court in a separate sheet, and such the conviction of trial is vitiates. So my humble submission, if there is a charge, that must be in a separate sheet, and that must be read over that he is a government servant, you have threatened to assault him, that has not been done. And he has in para 8, appellate court judgment.
He deals with that.
Yeah. I do not find the charges framed in separate sheet on separate heads of record. He disclosed that order 27 dated 21/109 in the order sheet that the charge were framed against the accused under 331, 294, 332, 506, 34.
But 332 is charge.
Yeah, no, I am not on that point. I am on the point that 332 cannot be amalgamated with those words. In 332, that must be specific that he is a government servant, and knowing that you have threatened him, that has not been done.
Where is the charge order?
That is in the accused statement. I don't have.
Yes, sir. What is
Judgment he has not provided us. Then also in appellate court, he has.
The prosecution shouldn't say that I don't have papers and all. Prosecution should have everything.
Actually, Lordship, when they are going the bicycle, at the time he said that he as a range officer, he asked them, what is the old what you are transferring, whether any authenticity document is there or not. They know very well that the person, range officer, is asking for the such documents. They threatened him and they have.
No, these are facts. These are
Yes.
facts. He is not disputing that.
Yes.
But the
Separate-
question
separate,
framed,
yes.
the question framed by the appellate court
That should be
is
separate.
answered in para 8.
Yes.
How do you respond to para 8? Is it sustainable under law? That's what he is asking. Just see para 8 of appellate court order. Appellate court order, just see.
Appellate court order, Lordship, page.
And address me on that.
Paragraph 2.
And particularly if the court disbelieves the witnesses insofar as the offense under section 341, 294 and 506 is concerned and record an acquittal.
Yes.
How can on the strength of the same set of witnesses can convict under 332? Same set of evidence. Disbelieve insofar as the other offenses.
What, Lordship? Because that
You would answer that.
evidence is not.
Apart from what the learned senior is raising the question, legal question.
Deposition copy is not with him for that reason I cannot.
Deposition, like, see, come to the IPC. Come to the IPC. What is the offense? Offense is 332. Just see. 332 is voluntarily causing hurt to a public servant from his duty. Okay? He has been convicted. He has been convicted. Whereas the other offenses are 341, 294 and 506. What is 341? Just see, come to 341. What is 341?
Wrongful restraint.
Wrongful restraint. He has been acquitted disbelieving that he is not wrongfully restrained.
Reliance sales from
And
evidence
294 obscene language he has not used. But at the same time, he 332 voluntarily causing hurt.
Language he used it.
But he has been acquitted from that. The debtor, the public servant, in due discharge of duty, generally 332 causing up.
Where is that? Where is the finding? Both the courts have not dealt with it. Read the 332. What are the immediate with? The trial court doesn't deal with the evidence at all.
But relying your also same set of evidence, he has acquitted the IPs other offences. With regards to matter
When was this
332,
offense? When was this offense? This incident in
this case, my lord,
2000?
since trial court judgment not provided matter in this
2003.
trial court judgment not provided matter.
You then take it from
the-
the court record and get ready next week. Sir, next week, sir. He doesn't have the copy. Next week. He understood. You answered this.
My lord,
Serious.
in this case, he has stated PW3, the range officer. PW3 has not stated if he was wrongfully restrained by any of the accused.
Yeah, what is that? What is that? Where are you reading, sir? PW.
Judgment, trial court judgment, page 8, para 8, page 3, page 5.
Wrongful restraint भी नहीं ताले कौन अच्छे हो?
PW3 has not stated if he was wrongfully restrained by any of the accused.
PW3 has not stated he was wrongfully restrained by any of the accused, and there is no evidence on record if the accused had caused wrongfully restraint to any of one of them. Is it the submission or it is the?
What happened in this case, my lord? In the appellate court judgment, in para 3, Uddhava Mahanta Pidol 2 has stated in his cross-section in the examination chief that on the one day, that is the year 2003, while he was accompanying the informant, Vijay Kumar Mahanti, for the purpose of patrolling at the little away from Muktapur High School at a Khajuri Pat, they noticed the accused persons carrying seized goods by means of their bicycle. Range officer tried to detain them. Accused persons abusing filthy language.
That range officer is PW3.
My lord. Holding stones.
He said that I have not. And again, very interesting. Para 8 you come, para 8 and 9. PW3 who is the range officer has not stated if he was wrongfully restrained by any of the accused person. There is no evidence on record if the accused person had caused wrongfully restraint to any of anyone. Hence, the prosecution has failed to prove the offence under section 341 and 34 IPC against him. And it is the evidence of PW3 that accused persons utter obscene words like so and so, so and so. PW2 has also stated that the accused persons utter abusive word that so and so, so and so. The above words are abusive words, but unfortunately, the prosecution has failed to show any annoyance, and if any of the causes so and so. 294 is executed, therefore.
Reserve judgment. Reserve judgment.
And this is hard copy.
In the revenue law and civil law, sir is expert. They are already running from him. Now it is comparing criminal case.
Criminal case.
See, experience has no substitute. And if you have experience, then you can handle anything. Which paragraph we were reading, sir?
The trial court judgment para.
Para 8 and 9.
Para 8.
And sentence 8 months. Sentence 8 months.
8 months, 2003 freezer, yes.
30.
30.
File has been misplaced. I will reconstruct my lord.
the counsel of the petitioner submits that he has lost his file, want to reconstruct the file, and therefore he needs 2 weeks time. 2 weeks time is granted for reconstructing the file, leave the matter for hearing and so on. And you take, get your pen drive and take the entire copy and reconstruct. 31. Yes. 31. Non-APS for the
But the
petitioner.
counsel appearing manner in 31 item, now he is holding as a assistant additional standing counsel. Mr. Harakrishna Panigrahi is now and panel as a additional standing counsel.
No, last date of hearing, nobody appeared.
Then he was appointed. Harakrishna Panigrahi. Harakrishna Panigrahi now additional standing counsel in government panel.
File तो आपन file registry दबो आपन कहीं चिंता करो आपन right on. When the matter was taken up on 11/10/2023, none appeared for the petition. Even the matter when matter is called up today, none appears for the petitioner. In view of the aforesaid in view of the aforesaid facts, in view thereof, Mr. Presenting the court has been appointed amicus curiae to assist the court. The registry is directed to supply a copy of the paperwork to the land amicus curiae. Lease the matter. When do you want, sir? Next week. Amicus curiae फटाफट करी copy. If you don't mind, take send your junior and take it.
Or if your lordship is give it
Pen
to
drive,
give it to pen drive, then
pen drive is easy.
काली नहीं की पिलानी ऐसे
आपनो कौन तो देख के
ना मेल आईडी दे दीजिए
pen drive नहीं है तो अब कौन तो डेट कौन
नेक्स्ट वीक आई नहीं दे नहीं 14 पे मु अछि कितने पार्टी दिबा लिस्ट आस ठीक सर only your lordship has passed over my matter.
Which one?
24.
Yes, what happened?
I have called Mr. Mahapatra also. He has sent his junior. He has not reached till now. Astila. Setine I would pull ponda astile.
Yes, please wait. He may come whenever he is there.
I have so much. I cannot go.
When he comes, you are out.
नहीं मु बाहर
when he is out, you are coming.
मु बाहर बसছি পুরা যাই নি কোন
ଆପଣ ଦେଖିନଥିବେ ଦେଖନ୍ତୁ ବାହାର ହେଇଯାଏ
ମୁଁ ଦେଖୁ ଯାଉ ଥର ଦେଖୁ
whenever you get come
କାନା ମୋର ଗୋଟେ ବେଳକୁ ଫିକ୍ସ ହେଇଛି ତ ଗୋଟେ
I know, therefore you whenever you come I'll take it up, don't worry. Yes,
32 মানে 32 33 my lord, both the cases my lord Mr. Devasi Sadang is my lord in a death sentence case have been put on file.
32 30
it only continue in the list my lord.
List how weekly कर ठीक है. Yes.
Simply adjournment will ask you. Simply adjournment next week. Next week, yes.
Yes.
34.
Yes, may
Yes, 34.
34 file has been misplaced, my lord.
Yesterday I was appointed as
Yesterday
I was appointed as amicus curiae.
Amicus curiae. You have taken the file.
Do you have the file with you?
No, my lord.
He has got the file. Both of you both of you assist. You be there, no problem. And he is young guy, let him argue. And be there.
I mean,
render some assistance. Let him argue. Yes.
May I please, your lordship? The revision is against.
Enter the appearance of yes. 34. Yes, sir.
The revision is against the conviction of the offence under section 47H of Bihar and Odisha Excise Act and sentence of 1 year rigorous imprisonment with fine of rupees 2,000.
Fine of rupees
2,000.
Okay.
As per the prosecution case, while the SI of excise Malkanagiri along with his staff
was patrolling, the petitioner was found preparing ID liquor. The SI detained the petitioner and in presence of independent witnesses, the search of the place is occurred. In search, one aluminum dekchi containing 15 kg of warmed mohua. Mohua was one earthen pot containing 20 kg of mohua was one earthen pot containing 7 liters of country liquor along with apparatus like bamboo pipe, earthen steel head and prepare liquor were recovered. Meanwhile, the on litmus test and hydrometer test, SI of exercise ascertained that the appellant was in possession of a country liquor and mohawk was. On recovery, the officer arrested the petitioner and seized the recovery materials.
Okay.
Then my lord, the sample of the liquor and mohawk were sent to State Drug Testing Laboratory, Bhubaneswar, and the report is Exhibit 4. My lord, in support of that prosecution case, they have examined 2 witnesses. Both are officials.
Both are
officials. SI excise.
PW1 is
the constable.
PW2 is the sub inspector.
Yes.
Except these 2 witnesses, nothing.
Nothing is there. Although they have claimed that at the time of seizure there was independent witnesses. In they have exhibited document 1 to 7 in support of their case. The defense they have also examined 2 witnesses. Witness W1 is the accused, and DW2 is the
when accused examines himself as a defense
witness.
And which provision?
Yes.
And which provision?
315.
Very good. That is the provision. 315. Accused can examine himself as a defense.
Yes.
Yes.
The DW2 is the neighbor of him.
Right.
Let's see. Here my submission here is that though they claim that present independent witnesses are there when the seizure was made, but they were not able to examine any of them.
Because para 5 says that during the trial of the case, the prosecution has examined 2 witnesses only, as the independent witness, in spite of repeated summons, did not attend the court forever.
Yes.
That is what para 5 records.
Yes.
Yes. What is your best point? This is one point. You say that no independent witnesses, only 2 witnesses, that is one is constable and other is excise inspector. And
para 8 of the trial court.
Come to para 8. Looking into such
looking to such evidence as SI of excise, it is found that his evidence regarding the presence of the accused at the spot is supported by documentary evidence such as seizure list exhibit and such as the presence of the signature of the accused upon the seizure list. Only upon the seizure list they are claiming.
the witness to the seizure.
They claim that there are witnesses there.
who are the witnesses, seizure witnesses? Have you checked it?
No. Seizure witness
See, there are two evidence. Try to understand. There are two evidence. Evidence of the constable and evidence of the excise inspector.
Yes, madam.
And they are bringing corroboration of those evidence through the seizure list.
Yes.
Seizure articles. Is there any independent witness with the seizure witness who could not be examined? Then the seizure is not proved. If seizure is not proved, there is no corroboration to the evidence of official witness.
There is no.
Then you are out.
Yes.
Simple.
There is no any. There is in the seizure
Seizure
list.
Seizure तो sign into. Have you seen the seizure list?
No, but.
देखिलो के sign करती seizure list?
सेटा में बाहर.
देखो.
Enter LCR से नहीं थे.
LCR नहीं. हाँ नहीं थे. LCR नहीं.
Automatically देखो, and he has now come. He has come now. I am giving a pause. Just check it up. Just see whether in the seizure list, if any independent witness is the seizure witness. If they are not examined, then seizure list goes. Then you are out. Yes. I am giving a pause.
Item 35 and 43.
No, that I'll take it up. I'm in between the hearing of this matter. These people.
I prefer adjournment.
Sorry.
I prefer adjournment.
Adjournment. See, I'll put it in the weekly list. Don't worry. Yes, sir. 15,000 rupees is the check amount. 10,000 he has deposited. He is going to pay you 5,000. I am disposing it. Bring to Monday.
5,000.
5,000 bring and give it. Finish it up here. Unnecessary. Again, dispute white.
Here.
Bring.
Your lordship record it and I will.
I'm keeping it. I remember it. Monday, you come and collect it.
10,000 it has been deposited before the
10,000 will be disbursed to him. And
before the
another
court
5,000 you pay and finish it up.
Yes, 5,000. I am calling.
Monday. Please do there this first item. Item number 1. This will be item number 1.
ଲୋକ ବିଛଣାରେ ପଡିଛି କଣ ମାସେ ହେଲାଣି ମତେ କହୁଛି ସେ ମାସେ ହେଲାଣି ବିଛଣାରେ ପଡିଛି ବୋଲି କହୁଛନ୍ତି ମୁଁ ଜାଣିନି
ଦେଖିଦିଅନ୍ତୁ sympathetically. Will also come. Again. Yes. Yes.
My lord, there is no seizure list.
I will do it. Don't worry. You can leave. लेकिन नंबर रख दीजिए. Again. Document. You can. Yes.
In LCR, there is no seizure list.
नहीं.
No.
देखो ना.
नहीं.
Exhibit देखो तू. Exhibit.
Order sheet देखो.
1/3.
नहीं.
Sir, exhibit 1/3. Exhibit 1/3. Signature of the accused. Signature of the accused. Seizure list. Exhibit 1.
Exhibit 1. Exhibit 1.
1 minute.
Exhibit 1.
Item number कौन फोड़ा जाए? 30.
34.
LCR is there. Just see. LCR.
Exhibit 1/1, signature of P1, exhibit 1/2, signature of P2.
Seizure list is 1.
1 and exhibit 1 they have manner sign in the exhibit. Exhibit 1/1, signature of P1, exhibit 1/2, signature of P2.
Signature of accused.
1/3, signature of accused.
Both the official witnesses. Lordship may kindly exhibit one by one. One by one.
One by one, where
That
is
is,
that?
that is signature of the P11. And exhibit 1 by 2. That is signature of the P22. That means both the witnesses, official,
Signatures are
no
on.
independent signature is there.
Where is the seizure list?
Yes.
What are
Exhibit
the?
one, my lord.
Exhibit
That is available with the
LCR.
LCR is nine.
Nahi.
LCR is the ninth seizure list. What kind of LCR is this?
Hard copy টা ଅଛି?
Judgment would have appeal memo.
Yes.
Appeal memo. List of documents filed. Also to show that the judgment.
Appellate court LCR order.
See, in the para 7, just read it. Para 7 of the trial court.
Yes, right.
In presence of the witnesses, he has also sealed those articles under the seizure list also. Which witnesses? No, none of the witnesses they examined.
They have not examined.
Then
Exhibit. There is
And my lord, trial court my lord, held that my lord, since despite of summons that did not appear for that.
so seizure list is, see, seizure list is not true.
That have been exhibited, my lord, as exhibit one.
Through whom?
To the IO and also the
Well, but,
1 and 2, my lord.
the-
And so also the accused, my lord, signed in the seizure list, my lord. That is admissible under law, my lord. Since all of them, though sometimes, my lord, seizure witnesses become hostile, my lord. That can be taken into consideration.
Secondary evidence.
My lord. And that happened, my lord, another thing, my lord. The MO, my lord, 1 and 2, the other materials, the petitioner, my lord, preparing liquor, my lord, that has been seized and produced before the trial court, my lord. That is the case. And another, my lord, the material, my lord, exhibit 4, my lord, reported drugs testing and research laboratory Orissa Bhubaneswar. It gets established that it is the liquid sample. ID liquor has been detected, and so also ethyl
Those things
alcohol.
are,
and
no
what-
witnesses are examined also.
May I submit one?
Document ki basis.
With, also, my lord, the evidence of Title 1 and 2, and also documented evidence of the prosecution case.
May I say something? What the prosecution has any hurdles to cite them as a witnesses to the prosecution? Because they are saying that seizure is prepared in presence of the independent witnesses, and they have not cited them as witnesses.
No, they have cited, but that
Cited, summoned, but didn't stand.
That isn't the case disposal.
they are claiming that.
And in fact, my lord, in the seizure list, the Title 1 and 2, and also accused signed, my lord. That are been exhibited, my lord, in the court, my lord. Exhibit 1, so also exhibit 4, my lord, and evidence of Title 1 and 2 taken person.
In the seizure list, because the accused signature is there,
My lord.
therefore it is exhibited.
My lord.
Confronted.
And so also the signature of Title 1 and 2 also there, my lord, in the seizure list. That has been proved, my lord. They have not disputed, my lord, denied that signature.
That's
my
the
lord.
difficulty.
Here the dispute.
And they have not stated that
the signature is of the accused is not a any.
and that what are the executive 4, my lord, that has, my lord, established the sample, my lord, the ID liquor detected and is ethyl alcohol, and all further the person was unfit for human consumption. I don't say for exemption.
We are not disputing that, but my lord,
The thing is, the signature of the accused is not independent. The signature of the accused is not
Not what?
from his free will.
How do you? Because he's in custody. That's what
Yes.
you want me to say. His signature obtained while he was in custody. That's what you want to say.
Yes, yes.
Tell whatever you want
Yes,
to say, tell,
yes,
no problem.
yes.
Let it be a mistake,
Yes, sir.
no problem.
Yes, madam.
We'll see, record and correct it. Why do you are hesitant? You want to say something, restrain yourself. Don't do that. So then your first point is, according to you, there is no independent witness, only there are two official witness, one is constable, another is excise inspector. So therefore, the testimony of these two officers should not be trusted for maintaining the conviction. This is the first point you have. Second point, what you want to say is, there is a seizure list, but the seizure list is not proved beyond reasonable doubts, because the witness to the seizure list were not independent witness to the seizure list has not been examined.
They are claiming
The
that
prosecution says, according to Mr. Ragada, what he says that the seizure list is well proved, because in the seizure list the accused had signed, which has been proved, and in the seizure list these two witnesses, official witnesses,
And
have all signed.
accused had not denied. Accused had not denied his signature.
And you have not denied the signature. That's what he says. To counter that, what do you want to say?
And
You want to try, you want to build up your case, saying that even if the two witnesses are believed, unless the two witnesses draws corroboration with other evidences, he cannot be convicted. The two witnesses, official witnesses, those who have been examined, their testimony could be drawn corroboration from the seizure list. If you can create reasonable doubt on the seizure list itself, then you are out. You develop on that.
they are claiming that there was independent witnesses. In their presence, they have sealed
Recovered the articles and prepare the seal and
signed
seize the articles.
Yes.
Okay.
And at the time of seizure, they get the sign of the accused. My contention is that the accused was not even present there.
Do you have any judgment to that? Have you tried? Mr. Ragada, he is trying hard, and let it be on Monday. Let him prepare his. He is trying Monday. Prepare further. You be there. You have a case, but you are not coming to the right point. So let him. Young guy, he should try. Why not? You try. I am keep it in Monday. Okay. You have a good case. You can develop it for acquittal. Otherwise, what I'll do is I'll maintain conviction, give the benefit of section 4 of POF and leave you. Let him get. And if you want assistance, please contact him. Please contact him, take the judgments and research on the subject and come on Monday. Okay. Okay. Yes. 35 and 30.
35 and 43 also.
35 and 43. ये रख दियो.
What था?
Weekly list रखता. Yes. Next.
36.
On behalf of Mr. Vasudev Pujari, I am appearing for the petitioner, my lord.
Yes.
As my learned senior is in another court, list the matter.
You argue, you try.
I have no power, my lord.
Power is not required. You are
That's
very,
why I've gone through the
you are very
record.
powerful. You argue.
That's why I have not
Tell
gone
me what is the case. Don't get scared. Tell me what is
The
the
file, but I have not gone through it.
You should have gone through. Once you come to the court, you must know what is the case. And please don't fetch.
Please the matter.
Hmm?
Let
What
the
are-
matter come next week, madam.
Okay, next week. But next week,
No,
come
no,
prepared.
please. Yes, yes, madam. And on which date, madam?
Next week. It will be remain in the what you call weekly leave. Get prepared and come. Yes, next.
Obliged.
Yes.
Yes, 7, my lord, in the last occasion, your lordship has directed to append to the T.K. Mishra as the amicus curiae, my lord. But due to the lack of communication, he didn't receive the file. Due to the lack of his telephone number. As per noting, my lord.
Why don't you give the telephone number to Mr. T.K. Mishra?
T.K. Mishra, Tusharkant Mishra, he was appointed. But due to his lack of his telephone number, he didn't receive the file.
Tusharkant Mishra?
Yes, Mr.
Correct. Collect it in use next week. Next. 38.
Against conviction, my lord. But the petitioner is convicted under section 47A of Bihar and Orissa Excise Act and sentenced to undergo RA for 3 years and fine of rupees 20,000, madam. RA for 3 years and fine of rupees 20,000.
47A.
47A.
Yes.
He faced trial, my lord, being charged under section 47A of Bihar and Orissa Excise Act, 276 by 34 of IPC, and section 181 of the Motor Vehicle Act. So far as the 276 by 34 and section 181 of Motor Vehicle Act, prosecution could not able to prove its case, and therefore he has been acquitted. So far as the Bihar and Orissa Excise Act is concerned, he has been convicted, madam. 9 witnesses have been examined on behalf of the prosecution. PW 1 and 2, they are independent seizure witnesses, but subsequently they have not supported the case of prosecution. So far as 3 and 4 are concerned, my lord, they are the witnesses to the documents seized in the seizure of that document of the vehicle. And 5, 6, and 7, they are the official witnesses. Based upon their statement, my lord, he has been convicted. And here is a case, my lord. The allegation is that 2 persons were in a auto rickshaw carrying some incriminating materials, my lord. That the carton containing 20 bottles
20
of
bottles of
Aristocrat rum
rum.
is containing 180 ml.
Okay.
The other 3 cartons were containing sealed bottles of belladonna spirit. Two of those packets were containing 70 bottles each, and each bottles were containing 200 ml belladonna spirit, my lord. And if the entire facts will be taken into consideration, my lord, that except that official witnesses, that there is no other matter against the accused persons, and independent witnesses, my lord, that they have been turned to, they have not supported the, they have turned to hostile, and they have not supported the case of prosecution.
Yes.
And my humble submission, my lord, if you also will have a glance to the entire facts and circumstances, admittedly, my lord, some allegations are there that if the official witness's statement were taken into consideration and the seizure documents. Here, my humble submission, my lord, that if you also will extend the benefit of POA, my lord, then.
Yes, Mr. Rao.
My lord, lordship may kindly.
Now, do you have any objection maintaining conviction, granting benefit of section 4 POA? What objection?
Yes.
Conviction is maintained.
Yes, my lord.
4 का benefit दे सकते 4 का benefit. Have you argued that section 4?
Section 4, so far as
Mr. Ragada, this excise, there is no legal bar for
No, there is no
where excise section,
PO.
section 4 PO?
No.
No legal bar?
No legal bar.
If he is first offender.
Yes, I am the first
He
offender.
first offender.
I'm the first offender.
He has did it way back in which year?
2000, that is
That time he was first offender.
2006, Lordship.
That time he was first offender. Thereafter he might have done it.
2006.
Mr. Tripathi conducted so many division based cases when criminal appeal matters. So many cases, my lord.
Okay, then section 4 will be. Yes, you see, in this case, official witnesses are there. Document is proved.
Document is
proved. Two independent witnesses to the seizure.
They will not do.
Turn no time. But how will he get over? It's better that. Yes.
39.
Let's say item 39, senior advocate Mr. D.P. Dhar is in another court. Kindly grant pass over.
Pass over?
Pass.
41.
Yes. 41. Non-APS for the petitioner. For the, in the interest of justice, leave the matter. Yes, madam, which matter? Huh? Item?
45.
45, let us take 40.
For
45, yes.
my lord, revision is against the consistent judgment of the learned trial court as well as appellate court.
Yes.
Allegation is under section 376.
Hmm.
And lordship may kindly see the statement of the victim, that is PW2.
What is the sentence?
Sentence 7 years. The lordship may kindly turn to first para 10 of the appellate court judgment.
Really, appellate court judge. You have
7 years.
in the revision, have you filed anything?
My lord?
In the revision petition, have you filed? Yes.
Yes.
Appellate court, huh? First
Appellate court
yes.
para 10.
Para 10. 1 minute.
May I read, my lord?
I am still searching your
Oh.
Appellate court.
That is page 12 of the
Yes, page
brief.
2. Yes,
Page
I
2.
got it.
Yes.
Got it.
On scrutiny of the materials placed by the
Where are you reading?
para 10.
10, on scrutiny of the yes.
Materials placed by the prosecution, it transpires that the prosecutrix, even though a major girl, has mental deficiency in the understanding the worldly affairs. She has no capacity to know the consequence of sexual relationship. Being persuaded and falsely assured by the accused appellant, he will keep her in his house. The prosecutrix surrendered herself before his lust and evil desire. Consent given by the woman who is unable to understand the nature and consequences of the act by the reason of unsoundness of mind doesn't amount to legal consent. Commission of sexual so and so. 11, my lord. The evidence of prosecutrix clearly reveals that she surrendered herself under a misconception of fact. It cannot be treated as valid and legal consent. It reveals from the medical evidence that the prosecutrix didn't attend her monthly period for about 2 months. Probably for that reason, the family members of the prosecutrix suspected a pregnancy which was found negative.
By that alone.
Your lordship may kindly turn to her evidence. Her evidence, PW2.
Yes.
It is hard to believe this entire occurrence.
Mm. 45, no?
LCR
Have stated.
First statement, PW1 is the informant mother, PW2 is the victim.
What is the material on record to show that she was unsound mind?
My lord, that is not borne out from the record, but it is said that she was unsoundness of mind. But from our evidence, it doesn't, my lord, reveal.
File, physical file. Paperwork is there? Huh? And evidence is nine. And evidence nine.
It is.
And she is evidence.
ଏଠି ଆମକୁ ବେଶୀ ଅସୁବିଧା ହଉଛି ଏଇଟା ନାଇଁ ଟ୍ରେନିଂ ପାଇଁ ନୁହେଁ କଣ ତମେ ଯାହା ହେଲେ ବି ତ ଦେଖିବାକୁ ପଡୁଛି ମୁଁ ଜାଣିଛି ଥୁଆ ହେଇଛି ବା ଚିଟ୍ କୋର୍ଟରେ ରଖାଯାଇଛି କାରଣ ତମେ ତ ସାର୍ଟିଫାଇଡ୍ କପି ନଦେଲେ ତଳ କୋର୍ଟ ଆକ୍ସେପ୍ଟ କରୁନି ହ୍ୱାଟ ଇଜ ଦ ମିନିଂ ଅଫ୍ ଇଟ୍
Yes.
Lordship got it.
Kunni Digal.
Prosecutors name
No,
Namita Digal.
Mamta?
My name is Namita Digal.
Namita Digal. Okay. The Digal. Yes. Witness number one, PW1.
PW2.
Two. PW2. Yes, PW2. Come.
Yes.
Let us-
Paragraph 3.
Yes.
Your Lordship, it is a fact that I am aged about 25 years at present. Only once I went to the house of the accused. After the incident, I didn't visited the house of the accused. My mother and Sahi people could know about the incident. My mother asked the accused to stop. My lord, I am not able to read out that portion.
As to why he took me
To his house.
to his house.
Yes.
Hmm.
Sunita is my younger sister. She is 3 years younger to me. I cannot say the day and the date when the accused took me to his house. When the accused called me to his house, villagers were present in the village. While I was present near the well of the village, accused took me by holding my hand. When accused made me on the ground, I didn't protest. My sari was not torn by the accused due to the activity of the accused. There
I
sustained bleeding injury on both of my legs. My wearing apparels also stained with blood. I saw the blood stain to
My parents.
ଏଠି ଦେଖାଯାଉନି
My parents.
my
I showed the blood stain to Thana Babu. Thana Babu.
yes, lost
Thana Babu.
Sari to Thana Babu. I also showed my injury to the doctor and police. After such pregnancy, I gave birth a dead male child on the same day of the incident. I intimated my mother.
That goes to show that she is mentally.
My lord, that she mentally, that may be, but might have been something might have. And another thing is, the paragraph 7, there was dispute between my father and the family of the accused prior to the occurrence. It may be a double-edged weapon, enmity. That is there. I don't say no. But keeping in view the fact of this case and also this aspect, on the very day,
After such
That is
pregnancy, I
the
gave
that
birth
is suggestions.
to
Lordship,
dead male
ମୋ ପାଖରେ ଆଉ ନାହିଁ
child
ଯେତିକି ଅଛି ମୁଁ କହୁଛି
on the same day of the.
ସଜେସନ ନାହିଁ ତ ଖାଲି ଲେଖା
it is
paragraph
not a
7.
disputed between my sister. It is not a.
No.
It is not a fact that.
The case,
Next line.
there was a dispute.
It is not a
ତାପରେ
fact.
ମୋ ପାଖରେ ଆଉ ନାହିଁ
No, no. Para 5, if you read it
Again.
once again. After such a pregnancy,
I gave birth
I
a
gave
dead
birth
child.
to a dead
On the
dead
same
child.
day, on
Full
this,
stop. Full stop.
on the
Next,
same
next
day.
you did.
Yes.
On the same day of for the incident,
I
I intimated my mother.
Yes.
These are two distinct sentences.
Yes, but.
Distinct sentences. You can't say that.
One sentence. That is there.
There is a full stop.
Yes.
The pregnancy and giving birth to dead child is one sentence. And second sentence is on the same day of the incident, I intimated my mother.
Intimated my mother. And my lord, your lordship, I have taken the, in my ground, I have taken the ground that the victim was 25 years old and was also could know what is what. Could able to.
That is
mentally, my lord, that is not proved. Whether she is mental patient or not, that has not been proved.
It goes with the presumption that yes, there was a consent, but it is not valid consent because she was mentally not fit.
If
that consent, even if she has given,
yes,
that consent
is the law,
not
my
valid.
lord.
That's
That
what
is that is the law. That is the law. I cannot change it. If she is of unsound mind, so I don't have a case. But my submission before your lordship is that she is 25 years old and could know about the everything. And she disclosed everything with to her mother on the very day. That shows that, but her mother's statement, the lordship may keep it to after launch.
FIR is lodged after.
ମୋ ପାଖରେ ସବୁତକ ମୁଁ ତାକୁ ଖୋଜୁଥିଲି ଦେଖିବାକୁ ଆପଣ ଡାକିଦେଲେ ତ ମୁଁ ପଳେଇ ଆସିବି.
What the best point what appears so far is she says that on the same day of incident I have been informed. Mother says that when 2 months there was no menstruation, she started doubting. Thereafter went to the police.
And it is found to be negative.
If the incident was informed to the mother on the same day, what prevented her not to go to the police? Rather, she suspected when 2 menstruation of the prosecutor was stopped, thereafter she went.
Yes.
This is a very dicey situation to address.
Yes.
This is what so far
Yes. Yes, my lord.
So you have to develop because continue. Shall I put it as a part head?
Yes, your lordship may keep it to after launch. Your lordship may after launch, your lordship may pass that order. Let me go through some other thing if I.
Well, put it next week. Don't strain yourself, really, because
That
there are
will be
many
better.
evidence. This is one of the things which apparently appears so far.
Yes.
But there may be some point there that might have been covered by this thing. You find out one thing, where from the trial court and the appellate court has got that the girl was unsound mind. Barring the statement of the mother of the petitioner, is there any scientific evidence which brought on record to suggest that she is unsound mind?
Yes.
Because if she was unsound mind, her testimony appears to be very carefully. She has in the examination, she is very systematically.
Yes.
She has said everything. If she is unsound mind, how she is narrating everything? And the trial court says that she had no clue about the consequence of sexual intercourse. Where from that observation the trial court gets?
Yes.
Unless there is some scientific evidence to suggest that she is unsound mind, or doctor who has been examined. Whether any question was put to him saying that whether he is sound mind or unsound mind or anything.
Yes.
That you have to examine. Do it, let us 7 years sentence. Only.
Yes, 7.
Next year, next week. Yes.
Okay.
Next item, 46.
Yes, sir.
I may pray next week because I am not ready. Due to badly placed.
Next week is okay. What are the offenses?
Offense he has been convicted 7 years.
These are also physically retarded.
7 years is
7 years and.
376. Oh, Mrs. Jana will argue and see, decide some judgment, you argued like that.
I have not gone through the.
Similar fact. Similar fact. Same day Rakhidwa. Jadi if she is arguing, some benefit can be given or whatever.
Hon'Ble.
Madam को जब रखिए again. ठीक है. ठीक है.
The Indian Penal Code and has been sentenced to undergo RI for 3 years and to pay a fine of rupees 5,000, my lord, and in default suffer RI for a further period of 3 months, my lord. Payment of with regard to payment of fine, my lord. My lord, allegation as per the
appellate court upheld, sir.
My lord?
Appellate court upheld, sir. Yes.
My lord, both the courts have, my lord, held that. My lord, here the allegation as per the prosecution, that my lord, the victim was working as a laborer in a nearby crusher on the date of occurrence. While she was returning, my lord, date of occurrence as per the prosecution case is my lord 4/5. My lord, as per the prosecution case, my lord, it's around 15 days prior to the date of lodging of the information. My lord, while she was returning, on the way she met the present petitioner, who is a co-villager, and on being asked by the petitioner, she accompanied with him. Instead of coming to the house, it is alleged that the petitioner took her to a different place, and it is alleged that she has been raped there. She stayed there for around 4 days, and in each day petitioner was committing rape. A specific case is that once in each day. My lord, to substantiate the allegation, the prosecution has examined around 9 witnesses, and out of the witnesses, my lord, and PW8 is the victim. My lord may see the evidence of PW8. Because the case entirely rests on the evidence of PW8, my lord. It's there, my lord.
PW8.
Got it?
PW8.
Victim, Vasanti Maji.
Yes. PW, PW. Yes, sir.
Valid. Here, valid. Paragraph 2. Valid. The occurrence took place around 8 months back. At that time, I had been to work in a crusher unit in village Bagudi. The accused Parshuram went near me, and I told that my father was ailing and that I should go home along with him. Then he took me with him, but not to my village and to some other village, and kept me in the house of an unknown person for 3 days. During those 3 days, father is
Bonawadi Maji.
Bonawadi Maji, 5.
Let us see why.
Nothing is there, but.
And he called for meeting many times.
Right.
He didn't attend, therefore he filed the that's perhaps the perhaps the explanation.
3 things are there, my lord. First thing, delay in lodging FIR. Second thing, not corroboratory medical evidences. Third, my lord, with regard to the age of the victim, my lord. With regards to delay in lodging FIR, my lord, the father, my lord, Title 5 stated that there was a little delay in lodging FIR due to the fact that the informant tried his best to search the accused. And since all of them are the Adivasi Majhi minority,
they rely more upon the panchayat than the
Panchayat,
police and all.
for that they search the accused and accused, but could not get him. And this connection, some days have been elapsed. That is one delay.
That is the explanation.
That is the explanation, my lord. And the subsequent written report submitted, my lord. And another thing, my lord, with regards to my lord, medical evidence, my lord, under the paragraph 11 of the appellate court judgment, my lord. But,
yes. Informant is PW7, man.
and what happened in this case?
PW7.
The evidence of victim girl,
Jagannath.
PW8, my lord, read out, PW8, that she has
Better that appoint a
Amicus
and
to
finish it up. Unnecessary, we can't keep on. Yes.
49, my lord. We don't have instructions. The petitioner was 63 years old at that in 2011. By now, we don't have instructions whether he's alive or not. I've sought instructions from the local advocate, my lord. Grant us some time and we'll have instructions.
At the time of filing of this petition is filed against the judgment of which court?
Assistant Sessions Judge Uddala.
Huh?
Assistant Sessions Judge Uddala.
No.
My lord, the
Additional Sessions Judge Baripada.
The appeal judgment.
Appeal judgment only you have challenged right now. The present revision is filed against the order against the judgment dated 21/9/2015 passed by the second additional Sessions Judge Baripada in criminal appeal number 35 of 2015, whereby the conviction and sentence passed by the court of Assistant Sessions Judge Uddala in ST case number 4 of 2011 dated 10/4/2015 has been upheld. At the petitioner at the time of petitioner was 63-year-old. 63-year-old at the time of
commencement of
at the time of trial. At the time of trial. The
time of the filing of this revision petition.
No. See, page 12, Assistant Sessions Judge, it is 63 it is written. In the year that is 2015, he was 63.
Man.
So now, how many years?
71.
71. At the time of in that view, the learned counsel for the petitioner submits that he would inquire about the status of the petitioner at present and inform this court. At least my point.
50.
Beg your pardon, my lord. My lord, item number 50, file is somehow misplaced, my lord. Allow 2 weeks time to retrieve the file.
Learned counsel for the petitioner submits that he has misplaced the file and want to reconstruct the same. 2 weeks time is granted to the petitioner to reconstruct the file and release the matter on such. After 2 weeks.
53.
In this matter, on last occasion, your lordship was directed to take instruction as to whether the
Your lordship, may kindly see the last order, that is 2/5/2024, wherein we were directed to ascertain the whereabouts and well-being of the present appellant.
He is dead, my lord.
And my lords, I
Govinda
have
Patnaik is dead. But in the sub-item, I am there, my lord, in GCRLA.
Dolo Govinda Patnaik is dead.
Yes, my lords. But I have received the instructions also.
Learned counsel for the petitioner submits that criminal appeal number 528 of 2009. Learned counsel for the petitioner and in the last date of hearing, that is on 2/5/2024. This court has directed the appellant to seek instruction regarding the status of the petitioner. Learned counsel for the petitioner submits that the petitioner has expired on
Yes, 5/5/2022.
5/5/2022. Mr. Rijvi appears for the state and confirms this fact. Accordingly, the present appeal is awaited. Okay,
And in the second, that is GCRL, government appeal, that may be taken up, your lordship. If
government appeal, what do you want?
I am ready.
Government appeal, there were 2 appellants, 2 accused in the court below. This
one is acquitted.
One is acquitted. Against his acquittal, we have come.
What do you want?
Well, Mr. Das is appearing in this matter. So will be taken up next week, my lords. He will
See,
appear.
I'll tell you, Duryodhana is acquitted.
Yes, my lords. Duryodhan Mahanti.
He was 80-year-old. And this Dolo Govinda was 76-year-old. He died. Do you think that he survived?
Your lordship.
And in the year 2015, Duryodhan Mahanti was 80-year-old.
8 years.
2015 kete varsh hala?
85 years.
No, that time he was 80.
89.
90 years.
90 years.
Near about 90 years.
This is correct.
Let it come next week and before Mr. Das will appear. And on that day, your lordship may dispose it. I will inform Mr. Das also.
Completely bedridden look at he made mane ketebele bhi come.
Better likho.
We have all sympathy towards the
Second
appellant.
Huh? Government appeal?
Perhaps he is pointing out that this is not your lordship's assignment. GCRL is someone else's assignment.
Arising out of the same judgment of.
Same judgment.
It can be heard by your lordships. Yes, here, madam. Your lordships can hear it. Your lordship can hear it.
Same.
Yes.
Assigned to whom?
Because all vigilance appeals, all the vigilance appeals is my lordship's assignment.
Oh, it's very simple. Judgment is one, evidence is one. So there should not be any conflicting findings.
Yes.
There should be both the criminal appeal and the government appeal, both will be tagged and it will be decided.
One day I'm keeping it, I'll dismiss it.
Yes, ma'am.
Because 80 in the 2015, let him die peacefully. Unnecessary. Acquitted is acquitted, no problem. I'll say that there is no merit, dismiss.
And the scope of interference melody in government appeal is very
once acquitted, presumption of innocence is restored to him. And he is a 90-year-old man. Let him die peacefully. Why to leave the world with stigma? You seek instruction, we will dispose it.
Yes, ma'am. Definitely.
Now, there in the year 2015, the respondent was 80-year-old. 80 years old. he was acquitted by the court below and confirmed by the appellate. Confirmed by the appellate court. Both the courts acquitted.
Yes.
Confirmed by the appellate court. The state has filed the present petition. Insofar as the co-accused is concerned, who was 76 years old in the year 2015, has expired. Therefore, expired. Therefore, his revision petition is awaited. Mr. Rijvi, on behalf of Mr. Das, request for an adjournment. Leave the matter on Monday.
Obliged, deeply obliged.
Ready, Mr. Rijvi?
Madam. नहीं 55, 56, 57 का टाइम लगा इतना कर दो.
Ready or we will put it somewhere as you. I include it in the weekly list?
Yes, madam. Weekly list.
Weekly include.
This
Roll over whenever you are ready. You can roll over
next week. Yes.
Preferably sometime in the 2 o'clock if you come. Finish up your work, come and so that.
55, 56, 57 is also mine.
So shall I put it? What I'll do is I'll include that in the weekly list. Whenever you are prepared, you can mention in the morning that I'll take it up
That will be
at 2 o'clock.
Yes.
So some matters will be over at least.
Yes.
Yes.
And you, sir,
Should be,
you think of for doing the oldest matter first.
All the matters are oldest.
13,
14.
13 is the oldest.
Finish up 13, though 13 matters you finish up.
I'm ready.
And if I can allow the maintaining conviction, if probation can be granted, you just simply tell me, I will pass that.
200 टंका पाइसे my lawyer friend can also agree.
But PC Act is involved and
special all our government
retired सब already अब तो वाली चला नहीं.
And PC Act I can't exchange the benefit also. That's the problem.
I'll see better.
Either acquitted or
convicted.
Will not get the benefit.
You check it up.
Yes.
See, I'll tell you one thing. Pendency of this proceeding after conviction itself is a penalty.
Yes, madam.
The trauma, the
entire family is.
So
I realize
that.
I realize that.
In that light, you think over.
Yes.
If something is there, we can tweak it.
Yes.
And record an acquittal, at least you'll get something.
Matters.
You think in that line.
That's in fact, a coordinated bench of this court, my lords, have passed in PC Act, PO Act. They have applied and they have disposed it of. I have that judgment.
Even if PO, he will not go to jail, but the benefit he will not.
Benefit may not get.
But there are, you find out there is a judgment. If PO Act benefit is given, it is equivalent to acquittal. There is a judgment, I remember.
Yes.
Okay. There is a judgment.
It will not stand on the way.
Yes. It will not be treated as a conviction.
It will not be treated.
After that 1 year, you successfully completed, then it is equivalent to an acquittal. Your slate is clean.
I will check
Get that judgment.
I will check it out.
I think there is one judgment.
What about case
If his behavior and conduct
is good,
yes.
then he is
and the certificate given by the probation officer,
then you are clear. Then you are clear. That's the whole idea.
Yes.
Because the
object is the same. Matter.
Criminal jurisprudence is not basically punitive. What?
Reformation.
Reformation. And we can give an opportunity and probation of offender check.
Yes.
Behave yourself 1 year.
And
he behaved. He got the certificate. Then
yes.
he is clean.
He's clean.
But to what extent he can take the benefit of that in the service jurisprudence is a question to be seen. If you can assist me, then 4 karke 3 observation deki chhad dawa so that they will get benefit in service law. Please do.
I will do some research matters on that.
Lords, in the last occasion, your lordship was querying about that fees of the amicus curiae. I have got one judgment of
Give
Justice
it.
S.K. Sahu. It was our case. So very old appeal. Mr. Justice Sahu has appointed someone has fixed that fee structure. Last page, your lordship is 10,000. 10,000 consolidated.
Okay. Appreciation of amicus curiae for entering valuable assistance and deciding here and ATM fee assessed to 10,000 in total, which will pay by the amicus curiae immediately. By who will pay?
Legal.
Yeah, this is an order of 1988.
Well, it's not
Criminal appeal decided on
20.
20.
Yes.
But specific direction, if you don't give, the amicus curiae can't keep on searching where from
legal.
Lordship may direct a registry to do the needful. They will
registry-
they will streamline, my lords.
Legal aid amicus curiae जो prevent करे अपन को आओ, who will be? So that direct we make the direction.
In fact, your lordship may also observe in the judgment that the registry to take the needful steps for payment of the amicus curiae fees. They will
Clearly,
streamline.
if you know
My lords.
X is going to pay, give it a
Yes,
direction.
yes, my lords. That will be more beneficial.
The youngsters will get some. Yes.
My senior saying that he had conducted more than 200 criminal appeals.
Well, after completion of 2 years or 3 years of the profession, I argued a case before Justice Honorable Justice R.C. Patnaik and G.B. Patnaik in court number 1. After hearing was completed, they called me to his office, the chamber. Said, I am entrusting you with this criminal appeals, around 300 criminal appeals. I said, my lord, I have heard that unless one will complete 7 years in the profession, she is not entitled to do the criminal appeals. No, I am the authority, legal aid authority. I am the chairman. I am saying you will do it. I could do maximum 100. After that,
Because of that only the product is in front of us.
But so lapse of so much time, we have also you are also on that stage also, and appointing the junior counsel judge.
We should give opportunity.
yes, they will be encouraged and they will prepare themselves.
As an incentive, they should get some money.
You will also be encouraging the youngsters. to
Incentive, at least they should get 10,000-15,000 rupees at least per
Yes.
case. And I have been telling them that please go to Mr. Ragada and get some judgment. Although he is opposing, he will at least.
Oh, he is.
Yes.
Recently, my lord, recent past, he has been appointed. Or otherwise, he was basically a defense lawyer.
That's always good that a defense lawyer is the other side and it will be easier for, So I'll do that 13 matters you get ready. And whenever you are ready, please come in the morning and mention so that after 2 o'clock we will set for you.
At least, yes.
And he will also be ready in that.
Yesterday, Lordship delivered 22 judgments.
Revision.
Most of judgment. That is benefit not only the litigants but also the members of the bar.
See, what is my view is, see, the pendency of the litigation for such a long time, it is a very traumatic thing for the accused. So that itself is a suffering. So
That
better that if anything is there, give it. And for a government servant, for small bribe kind of thing, try and.
All the lawyers are appreciating this.
That is always there, sir.
All the
Otherwise,
are good judges.
otherwise, we are not doing any service to the. Yes, let us proceed now. 57.
58.
Sir's matter is.
Sir's matter is from up to 57.
Up to 57.
Yes, my lords.
Okay. 50.
53 to 57.
So, weekly list jao whenever he is ready. Yes.
58.
Ours.
Yes, sir. 58.
In that case, in Lordship, there is a complainant is death during the investigation, which is not examined. First point is the PC case. Regarding the PC case, Your Lordship, in that case, complainant imprisonment for imprisonment for 2 months for the offence under section 7 of PC Act and further sentence him undergo rigorous imprisonment for 2 years and to pay fine of 3,000 in default to undergo rigorous imprisonment for 3 months for the offence under section 13 to 31 PC Act. Regarding to that, Your Lordships, the few fact is that before coming to the fact, Your Lordships, complainant who's died during the investigation is not examined. Second point is, Your Lordships, Tahsildar also is not examined. But who concerned officer regarding to that case, also he is not examined. Another point is, Lordships, the land code below also question about fourfold paper. Question about fourfold paper. The fourfold paper, which is under question by land code below. Another point is, Lordships, the examination of report, the chemical examination report.
How many points you have?
Also been disproved.
How many points you have?
I have maximum 7 points.
You tell me 1 point and develop that.
Yes.
Do you have a written submission ready?
Is a written submission, written note on argument दे दी जाएगी.
I haven't
already
received.
filed.
It's there.
Is it there on the record?
Yes, sir. Written note of argument filed.
Perhaps you have not served a copy on us.
Give a
Copy नहीं हो गया.
Give a written written submission which you have filed.
Again.
It is there on record. Give a copy to him. Let him also file a written submission. Then we will proceed. Then counsel for the petitioner has already filed the written submission in this matter. But the copy of the same has not been supplied to Mr. Rizvi. Rizvi, he may supply a copy to the learned counsel for the opposite party, Mr. Rizvi. Mr. Rizvi seeks time to file a written note of submission within a week. Within a week, lease the matter. Monday chadegi next Monday. 7 points. Each point you tell and show me. Likewise, best point first. If 1 point clicks, then further point I may not go into. Yes.
One more matter is left. 59 ta. Already adjourned.
Any matter is ready for hearing? List complete. Once we have a weekly list, then after this is exhausted, then we can start.
Weekly list.
Thank you.
It's about weekly. That's the one. Weekly.